May I please?
Yes.
May page 25, annexure 1.
Yeah.
With the order of honorable single judgment.
Yeah.
May I draw my lord's notice to page 26, paragraph 6.
Yes.
Having heard learned counsel for the parties and after going through the records, it appears that against the denial for grant of pensionary benefit, the petition have approached this honorable court for the government of Odisha in ST and SC Development Department has taken a decision to sanction pension to the directly appointed retired staff of ITDH and micro project pursuant to letter date 24/5/2017 under Annexure 17. Thereby, the letter dated 8/1/2017 under Annexure 8 issued by opposition party number 2 denying to sanction pensionary benefit to the petitioners cannot be sustained in the higher law. Accordingly, the same is liable to be quashed and here is hereby quashed. In that view of the matter, this court disposed of the writ directing the operator to implement the decision taken by the pursuant to letter dated so and so and extend pensionary benefit to the as express as possible. Preferably with a period of 6 months from the date of communication and production of certified.
What is this ITDA?
ITDA, Mala, that is an agency.
Integrated Tribal
Development Agency. Registered under Society Registration Act. Mala. They are not employees of the government.
Integrated
Tribal Development Agency. Registered under Society Registration Act. May I draw my lord's notice to
Just one.
sorry.
Who is the writ petitioner? Where was he working?
My lord,
Where was he working?
under the micro project, my lord, ITDA was working under the micro project in different districts. Paudi Bhunya Development Agency, Dongaria Kanda Development Agency, and Didai Development Agency, and Tumba Development Agency.
Where is that?
Else we can get it from page 41 of the writ petition, my lord, because in that writ appeal we have not annexed the counter filed by us. Page 41 of the writ petition filed before the honorable single judge.
Page 41.
My lord, of this writ petition, my lord.
Yes.
That was my counter filed before State Administrative Tribunal.
And what is this Paudi Bhua Development Agency?
These are the agencies. These are micro projects, my lord. Works for the development of tribal people.
So it has, it is not of this ITDA.
Yes, my lord.
The petitioner, the writ petitioner was not an employee of ITDA. This is your submission.
Yes, my lord. Even they are the employees of these agencies. And your lordship may I bring to my lord's notice page 36.
So where is the constitution of that agency?
That constitution of the agency that is not there, but they have annexed that. Your lordship can get it from their writ petition. At
Please.
Let's me see page 22 of the resolution of the government.
Yes.
22 of the read petition, my lord.
Yes. Yes.
Let's me the restructuring of stepping pattern of micro projects in order to implement specific programs focused on all around development of 13 particularly vulnerable tribal groups PBT 17 micro projects registered under the provisions of Society Registration Act 1860 are functioning in the state as to act as single point administration unit to monitor and supervise all government interventions in PBT areas. Due to intervention of more livelihood of hope funds, different sources, the workload of micro projects are increased substantially. On the other hand, the manpower structure of the micro are all equipped to sustain the increased workload, and it has become important to restructure the staffing pattern of micro projects. These are the stepping pattern of the micro projects.
Yes.
You'll also turn to page 37, 36, my lord. Annexure 8 to the read petition. This was issued on 11/1/2007, my lord.
Yes.
Sorry, 8th January 2007. May I read, my lord, that
Please read.
all the micro projects functioning under ST and SC development departments of the society constituted and registered under the provisions of Society Registration Act 1860.
Which paragraph you are reading?
My lord, I am reading at first paragraph of that letter, 8th January 2017, my lord.
No, this is annexure
My lord, Annexure 8 to the read petition, page 36, my lord.
36.
My lord.
All right. Yes.
All the micro projects functioning under ST and SC development department are the societies constituted and registered under the provisions of Society Registration Act 1860. All the micro projects have their own governing body. As per their bylaw, the collector of the district functions as ex officio chairman of the micro projects. Specific posts of micro projects are filled up on deputation of government servant, whereas other posts are filled up either on deputation or through direct recruitment by the micro projects as per the stipulation of Circular number 28/1979. Merely because of the fact that appointment of persons to the micro are done under the orders of collector of the district in capacity of ex officio chairman of the micro project, it does not confer the status of state government employees on such appointees. Thus, the directly recruited employees of micro are not government servants, and they are not entitled to get pensionary benefit under Odisha Civil Service Pension Rules 1992 and other welfare so and so.
Yes.
This was the subject matter of challenge in 2007. You'll also have seen that this is the letter of 8th January 2007.
Yes.
This was challenged before the State Administrative Tribunal in the year 2017, that is after 10 years.
Yes.
In the said case, counter was filed by the state's respondents. You'll also can find it from page 41.
Yes.
The specific stand of the state respondent before the state administrator that the applicants are the employees of Paudi Bhuya Development Agency, Dongoria Kanda Development Agency, Didai Development Agency, and Tumba Development Agency, which are micro projects in different districts. The applicants have approved the before the so and so. Well, paragraph 5. That it is some ITD and micro project being registered society, the employees of the society are not governed under the rules applicable to state government employees. So and so.
No, but why did you extend this benefit to the employees of ITDA?
Now we have
Who
not
extended? Huh?
we have not extended the benefit to the ITDA. Two sets of employees.
No, ITDA has taken a decision whether the employees of the ITDA are entitled to pensionary benefits.
No.
No.
That what's the difference? There are two sets of employees. One are deputed from the government to work in the micro projects, and another set of employees, they are directly recruited by the micro. So those who are deputed by the government, they are entitled to pension as per Odisha Civil Service Pension Rules 1992. Those who are the recruited under the agency, because that is a society, they are not governed under Odisha pension rules, they are not entitled to pension. In that is the decision of the government of 2007. By relying on letter, my lord, that they have filed it in IA number 268 of 2017. Honorable Single Judge has said that the letter dated 8/1/2007 has lost its force. My lord, may see that letter next to that 268 of 2022.
And when did he retire? This
Sorry.
writ petitioner? When did he retire?
If he retired, that appears from the court title.
There are a number of writ petitioners.
There are a number of writ petitioners. And 2017, they have not retired.
17, they had not
They are
retired.
not retired. Because in 2017, their age as it appears 52, 53 years, and some were 57 and 58 years.
No, but please come to the impugned order of the learned single judge.
Yes, ma'am. Page 25, ma'am.
Page 26,
Ma'am.
paragraph 6.
Ma'am. Having heard learned counsel for
Just
the
a minute, there's only this part. SC Development Department has taken a decision to sanction pensionary benefits to the directly appointed retired staff.
that I am drawing my lord's notice that letter. But that was not the decision of your lordship. See that letter.
So there are, according to you, the persons who were deputed in these agencies, who were basically the employees of the state government,
Yes.
they were held entitled for the pensionary
Pension.
benefits.
And this letter
Not
was
the employees directly recruited in the agency, in ITDA or
micro projects, my lord. They are not entitled. You'll also see that what is that letter, whether that letter says they are entitled to pensionary benefits or not. You'll also can find it from that IA filed by the applicants before Honorable Single Judge. That is IA number 268 of 2022. You'll also see that letter is annexure 17.
yes,
You'll also see that is letter. You'll also got it, my lord.
page.
Page that 9, that has been marked 9 to that IA, my lord.
All right.
You'll also got it.
IA number 163.
My lord, perhaps 163. There are 163. 9 to 8. 9 to 8. IA number 9 to 8.
163. Acha, 9 to 8.
My lord. Number 14.
Annexure 17, yes.
My lord. And this is a internal communication for collection of data only. Let's may see that letter. May I read, my lord? In continuation of this office letter numbers 1, 3 to on the subject sanction of pensioner to the direct appointment, I am directed to request you to kindly submit the information on last pay and grade pay of the directly appointed retired staff of here along with a copy of last for necessary comparison of data at this level.
Yes.
This is not a decision of my lord. But relying this letter, Honorable Single Judge are directed to give them pension, and the letter dated 1st August 2007 has lost its force.
So who pays them their salary and other benefits?
My salary was all the cost are borne by the central government, my lord. Only state government administer them. And they are employees of the agency. And they are not covered under Odisha pension rules, my lord. Your lordship can may I bring my lord's notice to Rule 3 of pension rules.
Yes.
May I read, my lord, Rule 3 of pension rules.
Yes. Yes.
Save as otherwise provided in these rules shall apply to government servants appointed in post and in service in connections with affairs of which are born on pensionable establishment.
Yes.
But our case that they're not born in the pensionable establishment and they're not the government servants. So they're not entitled to pension as per Odisha Civil.
Are they claiming pension under the pension rules?
Yes, my lord. They are claiming pension under the pension rules.
That's all.
Yes, ma'am.
Yes.
But my lord, the ITDA as well as the micro, they are under Society Act 1860.
No, first of all,
My-
satisfy us. How are you entitled to pension
My,
under
In
the
our-
Odisha pension rules?
yes, in our order of appointment, it has been mentioned that you will be governed by the government rules and whatever
Who has appointed?
the appointment order has been issued by the collector.
Collector in
Yes,
his
ma'am.
capacity as?
No, collector has issued. Some of them has been issued by the collector and some of the chairman of the agency. Here, my lord, they were appointed and they were appointed in a due process of selection. It has been mentioned in the
That is not important.
Yes.
You might have been appointed
Yes.
following due process of selection in a private organization.
The-
The question is, how are you entitled to pension? under
My
the-
lord, that I am submitting, my lord. All the petitioners, all the respondents, they were appointed in the order of appointment. It has been mentioned they will be governed by the government service rules, and that too, my lord, their service book have been opened. They have been granted. They have been given the GPF has been deducted each and every month, as has been done in service government servants. GPF right from the beginning. Some of them have continued about 36 years. They have retired. There are 25% what I see, and that to 3% in the meantime after the judgment has been passed, 3% have already died. Now, my lord,
Where is your appointment letter?
yes, that of course I have not given. If the lordship will permit, I will give.
Then it is very difficult.
Yes,
So that is the.
here, my lord, what
Must
happened?
be, there must
Yes,
be
ma'am.
something.
It has been mentioned, and that to GPF is being deducted. Apart from that, my lord, we will find that what my learned friend is saying that the ITDA is not getting it is not that. 1986 government has instructed the collector that all will be getting the benefit of the government. That 1986 the government has issued a circular. It is not that ITDA are not. ITDA and micro project employees, they are in the same. Some of them ITDA are continuing. They have been deputed to micro project. Micro project is interior part, and almost all our work are similar. They will promote the scheduled
There is
tribe.
no question of similarity. The
Mine.
question is of entitlement.
Minor.
They were government employees and they were deputed to ITDA or other agencies. Therefore, they being the employees of the government, they could not have been denied the benefit of pension. Now, those who were appointed by the agency to work under the agency, how can they be governed by the Bihar
No,
pension rules? That is the
My
only question.
ITDA, what my learned friend is saying that those who have been deputed to ITDA, they will get it is not that. There are also directly recruited ITDA employees and they have got the benefit of pension benefit.
Sir, the question is you will be entitled to any benefit based on your status.
But in my
The question is whether you are governed by the rules. That is the only question.
my lord, in the order of appointment, it has been mentioned that you will be governed by
The order of appointment you have not brought on record.
No, that.
And this is an admitted position that you are not working under any department of the government.
No, we are working in the ST and SC development department, and they were recruited they are recruited and they have been working there. Some of them have worked about 36 years and retired.
That is immaterial.
Yes, mine. Now, my lord, your lordship will find
One of the appointment orders you have included that
Page 13.
13,
Page
page 13,
13.
Annexure 1
Yes.
of the writ petition.
Yes.
here that is 9779 one Satyanarayana Prasad Kaur, that what I got. It has been mentioned that
Page
here the
13
paragraph is hereby
13 of your writ petition,
my lord.
sir.
Banwari Samal. Here, my lord, it has been mentioned that it should also the it has been mentioned that the employee should be governed by the service rules, leave rules applicable to temporary state government employee of Orissa. That has been mentioned there. So, my lord, now the ITD employee, the government has already taken a decision in the 1986. It is not that those were deputed. 1986, the state government has issued a instruction to all the collector that all will be governed by the state government rule. That is in 1986. And now, my lord, and some of them have been deputed to micro project. And micro project work, ITD work, all are similar work. Rather, the micro project, they will work interior of the tribal area. And that your lordship will find from the order passed by the judgment passed by the honorable single judge, where your lordship, I may permitted to place paragraph 5, my lord and friend has not mentioned. Your lordship will find from the paragraph 5 of the judgment passed by the Lord and single judge that your lordship may kindly have a glance to the paragraph 5 of the.
So this was your appointment letter,
My lord.
Annexure 1.
Annexure 1 in merit petition, and authors are also, there are 25 persons. Some of them I have not enclosed, where it has been mentioned. That to my lord, only the government employees, their GPF is being deducted. That to your lordship will find from the page 26 of the brief writ appeal, and paragraph 5, it has been contended. After I have argued the matter, your lordship will find paragraph 5 of the order passed by the honorable single judge, where they have said, Mr. J.P. Patel, Lord and Government Advocate, appearing for the state opposite parties, contended that now the state has already taken a decision to extend the pensionary benefit to the directly appointed retired staff of ITD and micro project. And it has been mentioned. And that too, after I argued the matter, I have placed all the documents. The honorable single judge has said now, and basing on the documents, Annexure 17, my lord and friend has placed that they have already taken a decision. Right from the beginning, they are taking a decision to give the benefit because they have been rendering about 36, 37 years of service. And
why are you repeating this? 36?
Because I am repeating
You might have worked for 50 years.
Yes.
That is the material.
And that too, your lordship will find it has been admitted by the government advocate that they are taking a decision. And that too, if it is not correct, then they would have filed an application for review.
All right.
And that too, my lords, when your lordship knows that the GPF amount is being deducted only from the government servant. And that they are also not getting any EPF amount. If they would have got the EPF amount, then the matter would have been different. Now, what they will do, they will not get EPF, neither GPF, nothing. How they will survive after working about 36, 37 years of service? And that when the government is taking a decision, it is apparent from the records. So it cannot be said that no, the order passed by the Lord single judge is
illegal. Who is your employer?
My employer is concerned collector, not that agency or chairman of the collector. Basing on the capacity of some of them have been appointed by the collector and some of the appointed by the chairman of that to my lord. Some of
you were appointed under an agency?
No. Agency we are working, but appointed by the collector, and that to my lord.
Why the collector appointed you?
Collector is the head of the district.
No, because he was
he is the chairman also.
Of the agency.
Chairman also.
So in that capacity he had appointed.
Yes, ma'am. Another part, my lord, I may pardon. Another part is that some of the micro person, those who are working, they have been observed, and some of the peons and others, they are getting pension. And now, my lord, they have been, this is a clear case of discrimination.
The question is whether you have been able to establish your right to get pension. That is the only question.
Yes, ma'am. That only, my lord, I want that I will give a counter to this.
No,
because
no counter.
No, because some of the documents I want to rely.
No.
Because after
in writ appeals, no counter.
No, because 2017, some of the documents were not placed.
Sorry.
Some of the. So, my lord, when they have admitted that the government is taking a decision to grant pensionary benefit to the retired employees, and basing on that, the writ application has been disposed.
All right.
Sorry.
Tomorrow. Judgment tomorrow. List is there tomorrow for that.
Item number 2.
Item number 2, Your Lordship, this contempt is infructuous as the Honorable Apex Court in the SLP has already stayed the contempt, Your Lordship.
What is this OTAPL?
It's a tax appeal, Your Lordship.
Don't press it now. We'll give liberty.
I think it will be infructuous, Your Lordship, ultimately.
Learned counsel appearing on. Counsel appearing on behalf of the petitioner states that this contempt proceeding has lost its efficacy. Stop. It stands dropped accordingly.
Deeply blessed.
Item number 3.
Lordship, in item number 3, on behalf of Mr. Sachin Sahu, I may be permitted to withdraw the present petition. I'm giving a memo to that effect.
Yes.
Item number 4.
My lord, in this case, I was supposed to file an rejoinder, which I'm permitted to file it in the court today. My lord, I also served a copy on the state. So let it come day after tomorrow. I think in this meanwhile, he may be gone.
File it in the registry. Learned counsel for
Let
the
it come day after
petitioner
tomorrow.
states that he shall be filing a rejoinder affidavit to the rejoinder affidavit on behalf of the petitioner to the counter affidavit filed on behalf of the state in registry in course of the day.
I've served a copy. Let it take.
A copy of this said rejoinder affidavit has already been served upon learned AGA. So stop. This matter as requested on behalf of the petitioner, list this matter on Thursday, Wednesday. All right, Wednesday.
Item number 5.
May I please, Your Lordship? In the given case, my lord, Your Lordships were in session over 2 WPCs. That is one WPC 163 of 65 of 2009. 163 65. My lord.
This is WPC 28.
Yes, my lord.
36.
My lord.
And which other case?
The other case is my lord WPC 163 65 of 2009.
2009.
My lord.
Where is that listed?
That is not listed, my lord. That was dismissed for non-prosecution pertaining to this very similar issue involved in this case, wherein the CBI has filed an affidavit before this honorable court that he is ready and willing to proceed with the investigation. And the other case is, my lord, 163 WPC 16379 of 2009.
So this has been dismissed for default.
This has dismissed because of the death of the petitioner of that writ petition of the of that writ petition.
16365.
No, 16379.
This was dismissed for non-prosecution.
My lord, no,
because of the death.
my lord.
So death, no substitution.
My lord, no substitution.
Then what happened?
My lord. Thereafter, my lord, the petitioner sought information under the RTI to what is the status of the investigation of the case, because there was allegation.
No, what is this matter about?
This matter is regarding, my lord, the petitioner is seeking directions for CBI inquiry into the matter of illegal transportation of iron ore, wherein the
Is this a PIL?
my lord. And because of non-sanction from the state of Odisha to the CBI to proceed with the investigation, the matter is in cold storage, my lord. And this honorable court was insisting over the matter. The matter was heard time and again. The CBI appeared before this honorable court, filed an affidavit that yes, I am ready to proceed with the inquiry, my lord. Therefore, my lord, this is the first matter. My humble submission is that, my lord, both the matters that may be connected with this present petition,
Which matter? One petition, which matter is pending?
that was disposed of, my lord. That was disposed of from non-prosecution, 16365/2009. Another is 16379 of 2009.
So both the cases were filed by the same person.
No, by different persons.
And the second case, the 23 case has been filed by whom?
By our petitioner, Pradeep Pradhan.
So how are they related? This 16365 and one.
Why I am seeking the Lord, your lordship's kind indulgence, only that the issue involved in are very similar to the same matter, wherein affidavit is filed by the CBI. Your lordship, for the kind perusal of your lordships.
CBI will not guide us. So why the investigation should be given to CBI? Why the court should direct?
Well, your lordship was insisting over the matter. That is my humble submission. Your lordship was examining the matter.
So
why the CBI investigation is required in this matter?
So why the CBI investigation is required?
Because
some offense has been committed according to you.
Correct, my lord.
Then file an FIR.
My lord, already there is an FIR.
Then
the state police proceeded with the investigation.
Then
the crime branch submitted the charge sheet, keeping the investigation open.
Then
that is evident on record, my lord.
Then
Annex 12, my lord, the information that was supplied to the present petitioner that we could not proceed because the matter was pending before the Honorable High Court, and one is dismissed for non-prosecution, and the other one was disposed of because of death of the petitioner there.
No, but why the investigation should be handed over to CBI?
My lord, because of the fact that a ship belonging to Singapore, my lord, has entered into the port of Paradip, wherein the illegal allegation is that, my lord, the illegal iron ore was being carried out without any sanction.
The question is whether the state police can investigate the case or not. If the state police cannot investigate, we can think of.
My lord, the fact remains that, with my humble submission, because the transaction relates to beyond the borders of the state. The cause of action relates to out of the country, my lord.
What is this?
That is of the year 2009.
My lord.
The transaction is in 2009.
My lord.
You want investigation today?
No, my lord. Why? Because, my lord, 2 petitions were filed. Your lordship took cognizance of the matter, heard the matter time and again.
Mr. Counsel, that is not a ground for handing over a case to CBI for investigation. That because this court was in session of the matter and the matter was heard time and again, for the court to direct an investigation by CBI, you will have to demonstrate that the state police either failed or they are conniving or what there is some circumstance so compelling that it should be given to CBI. It's not an ordinary circumstance. When the court directs for an investigation by CBI.
The compelling reason, with the humble opinion of the petitioner, my lord, is that the offense relates to transborder. The international transactions are there, my lord. The state police has limited jurisdiction to investigate into the matter.
How?
And the police has closed the investigation as of now without any further action. Though on record they state that the investigation, we are keeping it open.
What is this? Prima facie, it appears that there is some vested interest.
With humility, my lord, I am submitting.
Yes. This is prima facie opinion. So 2009 matter, you are coming in 2023, you suddenly you wake up after 14 years.
Your lordship only appeals to only one thing. Annex 12, my lord, page number 120, that I was supplied with information on 7/11/22.
Which information?
The information pertaining to the investigation of the case. The moment I came to...
Who are you?
But I am a public person.
Public person.
My
Have you filed ever any public interest litigation before this?
My lord.
How many?
We have to examine, my lord.
Huh?
We have to examine, my lord.
Examine.
My lord.
examine.
Because he is an
And
activist under the RTI,
I
my lord.
warn you, if we come to this conclusion that you lack bona fide,
My lord,
you will not be filing
Forward.
any PIL in future.
my lord, we bow down, my lord, we bow down.
Yes, no PILs. This court will not entertain any PIL filed by this petitioner.
My lord, we bow
This
down, my
would
lord.
be our verdict.
We will be bowed down, my lord. With humility and
Yes.
with sincerity.
Why, Mr. Why
Rule 8 not complied. Bona fide is not given.
have you not complied with Rule 8?
My lord, because the matter was pending before this honorable court, the moment I sought information under the RTI Act,
When was this writ petition disposed of?
that was disposed of, my lord, 26/4/2019, one thing. The other one is 14/3/2022, March 22, my lord.
Both the applications were disposed of.
The High Court wants
We
to
undertake,
file.
my lord, nothing will come to press. We
Huh?
undertake. I will advise my client.
How do you have control over the press?
Sorry.
My lord, let him file his bona fide. Let him file what are his credentials.
Let the petitioner explain his bona fide to this court for this court to maintain this public interest litigation. First off, he shall also be required to disclose his occupation, comma, credentials, and background, with background. By filing affidavit. Full stop. For this said purpose, list this matter on 1 week,
My lord.
retaining its position.
Lordship.
Your lordship is pleased to direct for a counter from the state in the meantime.
No, you first.
My lord.
That is right.
Deeply obliged, my lord.
Item number 6.
Item number 6, I am present on VC, my lords. My lords, on behalf of my learned senior, Mr. Milan Kanungo, I pray for a short adjournment.
As requested on behalf of the.
Yes, may I pray? It Lordship may call it 4 weeks after because it's regarding Lord's settlement of land in favor of a bank Lord's by the state government. So the process is going on. Lordship may he is seeking for arrangement. Lordship may grant me 4 weeks time so that in the meantime something will be Lord's done.
As requested on behalf of the estate, list this matter on 4 weeks. Stop. Land Council for Land AGA representing the estate has informed that in the meanwhile, the dispute raised in the present proceeding.
Dispute, Lordship directed for settlement of a piece of land in favor of this private bank, Lordship. It is the private bank. So the alienation proceeding and other settlement proceeding is going on between the parties.
This is going to live here. What is your name? What is your name? When did you join? Yes.
My lords, I'm deeply obliged.
Item number 7.
May I please, my lords? My lords, this matter order dated 11/5/2022 regarding grant of pension to the petitioner has not yet been complied. Kindly see order dated 12/22/12.
Yes, sir.
Yes, here in
Grant
fact,
of pension.
I'd filed an initial affidavit saying that matter I had gone to the Honorable Supreme Court, Milords. And the status of the case in the Supreme Court, that is not my affidavit dated 31/23/11. And we stated that, paragraph 6. As per the views of Law Department, SLP diary number such and such has been filed before the Honorable Supreme Court on 16/8/2023. If you will grant me a week's time, I will obtain the status.
May I kindly order 2212, my direct, 2212, my direct.
What is the case number?
SLP diary number. That is my lord, their
Diary number.
paragraph 6. 334.
Diary number 33400 of 2023. SLP diary number.
सुप्रीम कोर्ट साइट को ओरिजिनल साइट को बोले मैं
You don't have any idea about that Supreme Court case?
सुप्रीम कोर्ट ऑफ इंडिया नहीं डायरी को अच्छी काउंटर नंबर नेम कौन पेंडिंग
SLP number has been given.
କିଛି ହେଇଛି ଜଜମେଣ୍ଟ ନାଇଁ ସେଠି ତଳକୁ ଯାଆନ୍ତି ସେଠି ଅର୍ଡର କିଛି ହଁ available ହଁ what is that
So the compliance has started.
No.
Already
complied. Enter fully complied with.
No, in other matters?
Other matter also item 9.
Item 9 also
complied.
complied.
Or it has been stated by learned AGA, which has been admitted by learned counsel representing the petitioner, that this court's order, violation of which has been alleged in the present contempt application, has been complied with. Stop this The contempt proceeding stands stopped accordingly.
Item 9,
Item 9 also.
Same order.
Obliged.
item number 10,
Item 10. Mr. G.V. Das was gone for Mumbai for kidney checkup after transplantation. I pray 1 week time
So whether the order has been complied with,
that Mr. Kant.
who is there for the state? State is
No, it's not
No,
state,
no
it's a
state,
bank,
no,
private
it's-
bank, notes. We are not there.
In India.
bank.
This contempt petition, I'm the petitioner in the writ petition 23981. So that is nothing to do with the contempt, Miller. So that can be separated. That is filed by the bank, Miller. The issue is the secured debt
No,
versus.
who is the bank?
I'm the bank, Miller.
You are representing the bank.
In the next matter.
23981.
Just a
My
minute.
lord.
Who is appearing for the contender in item number 10?
Mr. Das representing who is taking
You are
adjournment.
the petitioner.
As it appears from the contenders were the bank manager and the sub-registrar.
So you are the petitioner.
No, sir, I am Mr. Gopabandhu Das who is suffering. He is the petitioner. I know because it's a connected matter.
No, but who is for the, therefore I am asking, who is the, who is for the
State
bank,
department.
for the contender?
Their bank, the manager, branch manager is there. The sub-registrar is there.
So who is representing?
I don't know.
State council.
He was representing the bank. My friend was representing the bank. So he can appear on their
Well,
behalf.
No, that is on the other writ petition, Miller, not on the
Doesn't
23981.
matter, you are also
So con-
the bank. right?
No, but if the
All right.
notice is issued,
Please let us be clear whether someone is appearing in contempt matter 8207/2023 for the bank.
yes, Miller, for the bank, notice has not been issued, so I'm not appearing on that.
All right. So do you have any idea whether the order has been complied with or not?
Miller, there is no, they say that there is an order, restraint order. In the meantime, bank has executed the sale deed under the surfacing. So that is the disputed facts, Miller. That is to gone into the matter.
All right, then both the cases are behind together.
So this 23981, I'm for the petitioner. Miller.
All right, all right.
That may be detagged, Miller. That is nothing to do with
We will
this.
see later. As requested on behalf of the petitioner in contempt in CONTC 8207 of 2023. List this matter on 3 weeks,
Week after, any day.
3 weeks.
Yes.
List these matters on 3 weeks.
But the interim order to continue in this 23981, Miller, there is
Interim
no-
order shall continue. Interim order
Only cases
passed
will
in
come together.
WP so and so shall continue in the meanwhile. Both the cases shall remain together. On the next date, we shall decide.
That is my case challenging the order of the income tax department.
We are ready to hear.
My lord. Interim order to consider.
We may hear your case first before the contempt.
Oblige, your lords.
That has nothing to do with your
Contempt, my lord.
So
That-
it has got some.
Nothing to do with the contempt.
Justice, this honorable court directed both the matters to be taken up. It correlates. It
No,
has
no,
got some nexus.
There was no hearing. The borrower said that this matter may be tagged. It was tagged. Lordship may hear for 5 minutes, still feel
we will see on the
that
next.
it, yes.
By court order, it has been tagged.
No, that's
On
okay. That's great.
On the next.
Oblige, your lords.
item 11,
Yes.
Right. In this batch of cases, a common judgment of the Honorable Single Judge, 2 orders is under challenge, my lord. The employees of this Christ College Cuttack, different employees with different prayers, approach this Honorable Court. Some with suspension, some with termination, some with the proceeding, dismissal proceeding, and some with payment of grantee. They approach. But at the first instance, but a point of law raised by the parties, whether this Christ College is a minority institution or a
Minority.
aided institution. That was the issue. That is on that point only the matter was heard. At the first instance.
Just a minute.
Sorry. At the first instance, because different prayers in different repetitions were before the Honorable Single Judge, it was tagged together and a common order was, the decision was arrived at by the parties that it will be only first, at the first instance, decided whether this institution is a minority institution or a aided institution. That is why the case was closed. Kindly play, my lord, that order I have not, I quoted that first.
But a minority institution can be aided institution also.
No, my lord, the minority, they are protected under this Odisha, the provisions of the Odisha Education Act, Section 2, given them a statute, they will not govern by the different provisions of the Odisha Education Act. Though they will get granted.
Yes.
They will get granted.
This is what we are saying.
Yes.
That the minority institutions shall not be governed by the general provisions of the state government act. But a minority institution can be an aided institution also.
Yes, madam. That is because there is a statute, madam. That is why I have stated so. Because all other granted as governed under this Odisha Education Act and rules from thereunder. So this is the broad aspect I have stated, madam.
Yes.
So whether this institution is a aided institution as per this provision of law or a complete minority institution, that was the first instance it was there. No merit was discussed at the, therefore the my lord both this Honorable Single Judge has closed the matter on this first issue. That order I have quoted, kindly have a glance to page 10 of the appeal, madam. This is an order dated page 10 of the brief, madam. Appeal, madam.
Yes.
My, this is the quoted person I am just placing, my lord. In WPC 315022.
So this order is not under challenge.
No, this order was not, but I'm just on this is the background, my lord. Otherwise, I could not place the case properly.
Yes.
My lord, what is the order is all these cases, writ petitions, before the single judge was closed in the this matter is taken up through hybrid mode. These batch of cases were heard and kept reserved for judgment. However, on mention being made by Ms. Pamirat, learned counsel appearing for the opposite party number 4 in WPC 1041421, that she had not participated in the hearing because of non-mentioning of her name in the cause list, the matter is listed today. Heard Ms. Pamirat and Mr. S.K. Das and Mr. K.K. Swain again on the point of status of the institution. This was the issue actually from the beginning. Ms. Pamirat files counter serving a copy of the on the other side, same be kept on record. Hearing is concluded and judgment is reserved. That I have shown this order because this was only heard and closed only with the point status of the institution, whether it is a minor institution or a aided institution as under Odisha Education Act. But judgment was delivered, my lord, in annexure 4, page 140. Judgment at the relevant is page 145, it starts 26/4/2023. Touching both the points on the first, the Honorable Court has held that this is a minority institution. No, sorry, yes, this is a minority institution, and it has also touched the merit of the cases and accordingly held, though on the merit of the case it was not been heard because it was closed on this point because individual claim, different claims when different writ petition
No,
was claimed.
is this your submission that the learned single judge has dealt with such issues were not there in the pleadings on record?
No, pleading, but there was no hearing on the issues because it was closed only on the point of maintainability. Because the merits, it was not hard because we are the councils, my lord, we know that was not never touched on individual claim. This is pleading. Otherwise, how could he file the writ petition? Filing of the writ petition, this point was not there.
Mr. Please come again to the paragraph which you are referring.
Page 10, my lord.
Yes.
Yes.
So MS Pamirath wanted to address the court on the question of status.
No.
We don't know what had happened before that.
Before that, all the orders are there, my lord. Because I have not filed, because the Honorable Court's order is there.
Therefore, this is only for Ms. Pamirath who was not heard and she wanted to be heard on the point of status.
No, that the case was closed.
And before the learned single judge, the entire pleading was there on record.
No, pleadings were there. It was not argued. If my lord will call for the record, my lord, because I have not filed all the orders. It is there on record. If my lord will permit it, I will get the copies.
If that is one of your points, we are not inclined.
No, my lord, that is the first point. So for the on the
But you have
status
filed,
of the.
but you have filed review thereafter.
Yes, I have filed it. Therefore, I have filed a review. That is why I have filed a review. And the only if my lord will see. First, page 145. What it is stated in that page 10, I quoted. My lord, finally see the judgment of the Honorable Court, page 145. First and second paragraph. Shall I read, man? Page 145, yes. On 26 April 23, this is the judgment, man. Whether Christ College, Cuttack is a minority educational institution within the meaning of Section 2 of the Odisha Education Act 1969, in short the Act 1969, is the preliminary question to be determined all these writ petitions. This is how the Honorable Court proceed. The other question to be determined is as to if these writ petition would be maintainable regardless of the answers to the preliminary question. My humble submission, this point was not the first point, was the hearing, my lord. The petitioners in this writ petition, except WPC 4075/14, WPC 11862 of 2011, that will be 14, are top of.
We are not convinced on this point. We are not convinced.
That I'm reading.
Aspect.
Yes, ma'am. So, are staff of the Christ College and are aggrieved by the action taken against them by the governing body of the college. Since the preliminary question as above was raised with the consent of the parties, the said question was taken up, determination of at the outset. Review in time, it was filed. In time. Only the second paragraph again, my lord, just for my lord's convenience, though my lord have opined. So kindly, my lord, second paragraph of the impediment. The petitioners in the writ application, except WPC so-and-so, are staff of Christ College and are aggrieved by action taken against them by the governing body of the college. Since preliminary question as above was raised with consent of the parties, the said question was taken up for determination at the outset. Since this issue is common to all the writ petitions, they are heard together and are being decided by this common judgment. To such extent, therefore, the fact of each of the case are not required to be gone into at this stage. That is why I said, my lord, it was hard on the question of whether the status of the institution. But finally, my lord, what happened? The Honorable Court has held this is a minority institution, and also subsequently by referring to some judgments have said that these writ petitions under Article 226 are not maintainable. This was the order. Against that, my lord, all these writ petitioners have filed review petition, respective review petitions with this ground. The review petitions were also disposed of by a common judgment on 14 December 23, dismissing the review. That is why the present appeal, my lord. Before the review, in the review, this was the sole ground what I have stated here, that because that is not been hard on merit, that is why it is to be decided. First, thereafter, if the first point goes that yes, it is a minority institution, then we may be given an opportunity to whether our claims can be maintainable under Article 226 or not. But the Honorable Court has held no, that order is good. So since that aspect of the matter, whether the individual claim has a nexus to the claim to this petition against the, because some claim are against the government, because some of them are on receipt of granting aid, some are to get pension under the pension rule of the state. And so far the pension is concerned, the division bench judgment of this Honorable Court is, it is maintainable. So, but the Honorable Court has held none of this claim of these, all these 3 or 5%, whoever that is before the Honorable Court, is not maintainable. So that aspect of the matter, even for the argument's sake, considering that yes, it is a minority institution.
The stand which you are taking is not in a good test.
Subject to my lord's approval only. So far the merits is concerned, because my respect submission is, let us assume that it is a minority institution. That there also we have a reservation, I will submit, my lord. But let us assume it is a minority institution. Because the Honorable Court, because I will show each of the prayer, suppose I have filed 4 cases, each of the prayer I will show, my lord. Most of the prayer relate to, one of the case, my lord, relate to pension. One, there is a dismissal order. I have challenged their order also, what they have done, my lord.
Maybe the single judge has held that it's a minority institution, one.
Yes.
And therefore the rules will not apply, the government decisions will not apply in their cases too. And no writ can be issued under 226(3). These are the,
to the second point, my lord.
The core is.
Yes, that's to the second point.
Yes.
Whether these writ petitions with the prayer made in the individual writ petition, whether it is maintainable under 226. That is a subject matter also. My responsible submission is the Honorable Court has not gone into that aspect of the matter, which are very much available on the issue. The Honorable Court has gone to a Supreme Court judgment and decided all the cases. But the case relate to, that is a 22 SEC. That is relate to unaided institution, not to aided minority institution.
Which is that of Justice, Honorable Mr. Justice Sikri on minority. That is the, that.
Take many judgment, my lord, therefore I folded it. Can you have a glance? That's what I am to refer it.
Give us the citation.
That is, my lord, 22 live law SC.
Live law,
my lord.
Why not SCC?
SCC, I could not get, my lord, the citation.
Yeah, what is the name of the party?
Party is, my lord, St. Mary Education Society.
That is 2022 SCC online SC 1091.
Oblige, my lord.
Rajendra Prasad Bhargava.
Yes.
That is referred to in page 190 in the review order.
Yes, madam. That I got the SEC online. That I have a glance to the copy. Shall I pass on? I've given other judgments also. Therefore, I folded it. I'll have a glance to it. That the honorable single judge has referred to this judgment while dealing with the review and said that this is, the order is good. But this decision itself, this institution is a private, unaided minority institution. It is not an aided institution. This is the distinction at the outset, madam. That is why in
Yes.
By referring to the other judgments, the Honorable Supreme Court has come to a conclusion, yes, for private unaided minority institution, writ doesn't lie. But here is a case, my lord, our institution is getting grant in it from the state government. And the various provisions of the Odisha Education of that, on fact, I will place, my lord.
Yes.
Under various provisions of the Odisha Education Act, orders have been passed and this institution has accepted.
Yes.
And it is receiving direct payment from the government. It is not receiving grant in it under the circular available to the minority institution, because Odisha government has issued a circular.
So what was the dispute in your case?
In individual case, my lord.
Yes.
Yes. My lord. So if my lord will help this
Whether that related to service condition or something else?
Yes. Service condition not related to this institution. Suppose first case, I have 3-4 cases. I will individual. I will see. The first case, my lord, see. Here is a case. The first case, my lord, is holding the brief. She was.
We don't hold brief, Mr.
Oh, sorry. My lord is online. Yes. Sorry. My lord. This Smita Raut, Smita Naik. This case. So, my lord, she was approved. She was duly appointed. She was approved. And she has also received grant in it from the state government under the direct payment scheme. Because the state government has a modality how to pay. The direct payment scheme is only from the provided under the Odisha Education Act.
Not in dispute.
Minority status is in dispute in this particular case.
Right.
I'll show my lord. Because this point, both the points were raising, but my lord want to know.
On what ground?
Yes, my lord, what happened? There are 2 institutions, there are 3 to 4 institutions in Odisha. There are 2 colleges very adjacent to each other in this Cuttack town. One is this Christ College, another is towards Science College, towards Bakshi Bazaar. My lord might not have known, but these are in that very close vicinity, my lord Justice Raman known. So these are the 2 institutions. Running in the status, according to them, it is a minority institution, because they are saying we have been founded, monitored, administered by the minority, Christian minority. That was the concept. But in 1998, a dispute was arised with regard to constitution of the governing body of the college. In fact, the governing body of this college was constituted as per the provisions of the Odisha Education Act. Had it been a minority institution, my lord, as per section 2, none of the provision of the Odisha Education Act or the rule would have been made applicable to the institution. But for these particular institutions, the governing body was approved by the director, who is the competent authority under the statute. So they have accepted that, they have acted upon such governing body. It is not once, my lord, number of times. Because
therefore, though the institution was established as a minority institution, because subsequently governing body was changed at the instance of the government, therefore it's a minority.
Not instance of the governing body, not of the instance of the government, at the instance of these so-called minority.
Whosoever. The fact remains that it was established as a minority institution.
No, my lord, that fact is also in dispute. That is the problem.
That you can file a suit then.
No, that is the point, my lord. This was just I'm telling the history of these institutions.
You can file a suit.
One institution came, these 2 institutions, these 2 colleges, Towards Science College and this Christ College, they were before this honorable court with regard to the status of the governing body. The governing body status was decided, the honorable court, basing on a government resolution. Single bench of this honorable court.
They have a right to establish.
Yes, my lord. May I be permitted? My lord, what happened? First judgment came in 1998 by
nothing much, Mr.
This is the
law has been decided by Supreme Court.
Yes, I'm coming to this, my lord. With this particular case, my lord, I'm just one more fact, 2 judgment, my lord. The first judgment by this honorable court with regard to Christ College and Stuart Science College was in 2008 by the honorable single judge, holding that these are the 2 minority institutions. But thereafter, my lord, again the dispute came before the division bench, not arising out of this same law, but the same judgment was again tested before the division bench of this honorable court. The division bench in Shamal Kumar Saha, There the Honorable Court has said, therefore with the judgment of the Honorable Single Judge, the Honorable Court came to a conclusion, Division Bench has come to a conclusion that in order to get, by referring to the St. Mary College case, in order to get the status of a minority institution, you have to obtain a certificate from the National Commission. Might not know that Minority Commission, Education Aided Institution Minority Commission 2004 Act has come by the time. So it says, since there is a dispute with regard to the status of the institution, let them approach the commission to get a certificate. In fact, that Stuart Science College, Cuttack, after the Division Bench judgment, moved the National Commission and obtained a certificate that it is a minority institution. And accordingly, it is continuing. So, for this Christ College is concerned, they didn't move. While this case was, this present dispute was before the Honorable Court, they have filed a petition before the National Commission, and that was listed in the last, we have verified, on 31/3/2023. It was listed before the Commission. In the cause list, I have also filed in before the Honorable Single Judge to show that, because that application has also not yet been decided. No certificate is to that extent is been issued. What they have relied before the Honorable Single Judge
Who is
was,
for the other side?
no
Who is for
notice
the-
has gone.
Huh?
No, state is there, no notice has gone to the management. This is the first time it has come.
Should we issue notice? Issue notice.
In the second case, my lord, filed that affidavit, supplementary affidavit. And an application, my lord, just one prior was, one order was not there. Seeking your permission, my lord, to amend that portion.
Let them come.
All other cases I am appearing, my lord. All the cases I will take notice. May be permitted to serve the extra copy on the State Council. Other I will take notice by
Let
registered post.
requisite number of the appeal memos be served upon learned AGA representing the state who has accepted notices on behalf of opposite parties number or respondents or opposite
Opposite party 1 and 2.
one and opposite party or respondent?
Respondent. Respondent 1 and 2.
Yes.
3, 4, 5 I will take notice.
Governing body, principal and
This
Cuttack
question.
Education Board.
Yes. May registered post.
Yes.
Item number 12.
My lord, I am on behalf of Mr. Patnaik, my lord, I am submitting, my lord. This is the public interest litigation, my lord. My lord, one Bijoyini block Mission Shakti Mahasangha, my lord. It is a block level federation, my lord. And this
Public interest litigation 12.
pardon, my lord.
Just a minute. Yes.
May I proceed, my lord?
Yes.
My lord. And my lord, one Bijoyini block Mission Shakti Mahasangha block level federation is operated in Bhubaneswar. It is the block level federation, my lord. It is running since 2005, my lord. And its activities is beyond the operational manual, for which I came before the Honorable Court, my lord, in the writ petition. One of the deficiency, my lord, as per the operation manual for federation, your lordship kindly have a glance to page 31. 512 role and responsible.
No,
of the
what do you want?
My lord, there is a, in the meantime, my lord, there is a audit report which seems that they have violated all the conditions of operation manual, my lord. Your lordship can have a glance to page 52. What is
Who
the
has
audit?
audited?
What is the audit report submitted, my lord? What is the irregularity, my lord? 52, my lord.
Who has audited? Who is the auditor?
The Auditor General, my lord, the Principal Accountant General has audited that.
Under which provision?
Under my lord, there is a provision in the manual, my lord, operation manual, my lord.
Which operation manual?
Operational manual of SSG Federation in Odisha. It is under Department of Women and Child Development, Government of Odisha.
This is your understanding that the CAG conducts audit under some circular.
Here, my lord, there I am placing.
Is there any constitutional provision?
No, my lord, it is a federation, my lord. It is registered under the.
This is with respect to federation.
Yes, my lord.
Which federation?
Federation, it is the HSG Federation, my lord, in Odisha. Page Annex 3, page 23, my lord. It's a Department for Women and Child Development, Mission Shakti, my lord. And there is a, my lord, that there is a provision for audit, my lord, for within every years, my lord, where the accounting process.
SSG Act?
My lord?
This Mission Shakti
My lord.
is formulated under self-help group
My lord, my lord.
provisions of the act?
Yes, my lord. And my lord, on the rule and what is the rule of a responsible president and what is here, my lord? The president and secretary is running, is occupying this chair, my lord, since 2005, my lord. Whereas it is stipulated that within 2 years, they have to further elections shall be conducted, and further president secretary shall be elected, my lord. And they are continuing since then by violating the conditions. So also they are not the member of the GP committee.
What is GP?
Gram Panchayat, my lord.
Then
Yes, it's there in the government, state government. It stated, my lord, that
Mr. Counsel, please understand that you have a Chief Justice who has come from outside. So he may not be knowing the local laws.
My lord.
Please refer to the provision.
My lord, for becoming a president and secretary and the treasurer of the office bearer, the person concerned.
Of what?
Office bearer of the federation, block level federation, my lord.
Which federation?
SSG group federation, my lord. This is the one of the self-help group, my lord.
Self-help group has been constituted under some act.
No, it is under the Mission Shakti, my lord. In the Odisha, in the Mission Shakti.
Mission Shakti is not an act.
No, it's not an act, my lord.
My lord wants to know what is that act which deals with this SSG.
It is, my lord, under the Department of Women and Child Development, Government of Odisha.
What is the act, sir?
It is not an act, my lord.
These are all society
registration.
Registered under this Registration of Societies Act. And
Special help group to check. Yeah. What is that? Special help?
Self-help.
Self-help.
SSG Act what is it? Odisha special self-help group.
Yes.
What act? अच्छी नहीं अच्छी एक्ट अच्छी ओडिशा
The name of the act is Orissa Self-Help Cooperative Act 2001. So it's under the cooperative, it's a act of cooperative act. It there mentioned at page 24, you will see the act has been mentioned. My friend have to get it because I also don't have that book.
The state cabinet also gave its approval for the Odisha Self-Help Cooperative Act.
Yes.
2001.
Page 24, my lord. The state cabinet also gave its approval
for the Orissa Self-Help Cooperative OSC Act 2001. Expecting to the contribute greatly to the women SHGs in Orissa, especially the microfinance activities and the initiatives.
Could you get that act? Do you have that act?
I don't have my. So, my lord, in 2023, the auditor has been conducted, ma'am. And since 2005 onwards, that has not been, no audit has been conducted. So, my lord, in the audit, what is the deficiency they have pointed out? My lord, in 52, my lord. Outstanding principals and interest dues from the SSG beyond the stipulation period 24 is the one of the part, ma'am. Your lordship, as of May 23.
So what is the provision if the audit has been held? Then who will deal with the irregularities?
The auditor has been stated into, my lord. I am just placing, my lord. Besides, the SSG had
See,
been
Mr.
sanctioned.
Counsel, we are making this clear.
My lord.
That only based on the auditor's report, the court will issue no direction. All right. Unless we know that there is a provision everywhere, whenever there is a requirement of the accounts being audited, then the auditor's report is required to be placed before a body.
It is placed
to consider that report.
My lord, the CDPO stated BLF, Block Level Federation, would be initiate submit clarification on these issues, but they didn't. And my lord, in reply to the in another point, loss of interest so and so, that has been accorded here. That in reply to CDPO stated steps should be taken.
What do you want us to run this?
Then my lord, I have already given the representation for taking necessary actions. So to the collector, so and so the CDPO, but it has been pending, my lord. It has not been taken care of because there is a deficiency in the audit report.
So when did you make that representation?
My lord.
When did you make that representation?
Document direct to the concerned authority.
When did you make that representation? Can't you answer?
My lord. 2023, my lord.
When did you file this writ petition?
My lord, it is
1 hour after that.
No, my lord. It is 23, my lord.
Huh?
It is 23.
You are saying
December.
24.
No.
December 2023.
23, my lord. 3 months, my lord.
Huh?
2.5 months.
2.5 months thereafter you filed the writ petition. Because your representation was not considered.
And representation was filed by one advocate, whereas the writ petition has been filed by somebody else. No?
And he is the one of the.
Repenting is referring.
So why did you not represent? Your advocate filed.
Yes, my friend, one of the advocates filed, my lord.
At your instance, or he was holding wakalatnama?
No.
The advocate filed the representation in his individual capacity, or at your instance holding your wakalatnama?
No, individual capacity.
Please don't misuse the process of PIL here. The consequences may be very serious. We are also waiting for one of the cases. Just coming back.
My lord, I will get prepared, my lord, coming with the book, my lord. Your lordship may take over this matter in no. Well, I am withdrawing this case, my lord. Permit to withdraw.
And counsel for the petitioner, after some arguments, seeks permission to withdraw this writ application in the nature of public interest implicated. This writ application is accordingly dismissed as withdrawn. Stop. Next, the dismissal of the present writ application by the present order shall not come in way of the petitioner pursuing his remedy before appropriate forum in accordance with law.
Item 13. Item number 13.
Someone was seeking adjournment, no? No. There is no representation on behalf of the petitioner. Let's this matter on next week.
Item 14.
Item 13.
Yes, where were you?
13. 13.
Please,
May I please?
please. You want publication of result?
Yes, Miller.
Yes.
Miller, the matter related to directed the opposite part number 3 for properly publication and correction of result in M Pharma first semester back the 2014 to 15, Miller.
14 to 15.
Yes, Miller.
Why so early? You have come to the High Court?
No, Miller. At the time, the petitioner has completed all criteria and he has submitted representation to opposite part number 3 as per the provision of guidelines, Miller. And after submitting the representation, the college of petitioner, namely opposite part number 4, Miller, he had communicated to opposite part number 3 for correction and publication of my result, Miller. But other than that, they have not complied. My mark sheet, Miller. And the petitioner had also appeared all examination, Miller.
No, you had appeared when?
Miller.
When had you appeared?
Miller, kindly see Annexure 7, Miller. My attendance sheet.
When the court is asking when had you appeared, you are saying you see Annexure 7 or Annexure anything. When had you appeared in the examination?
2013 to 2015.
All right. So why have you filed this writ petition in 2024?
Because they have not allowed to me, not allowed in my favor for my result, Miller. And I have the petitioner have submitted, petitioner have appeared before the examination center and who had appeared all examination. But they have remarked he is absent, Miller.
When?
Kindly see, Miller, Annexure 7, Miller.
Why are you coming to this court 10 years after you had appeared or you had not appeared in the examination?
My representation and my grievance is pending before
That is very difficult.
Your representation you have made in 2023.
23 also before, Miller, Annexure 5, my representation is there.
Sorry, sir.
And opposite part number 4 also communicated to Miller.
Annexure 5 is also 21. After 7 years from the date of appearance in the examination.
Miller, kindly Annexure 3. Annexure 3. This order letter is communicated to opposite part number 3, Miller, from opposite part number 4 for correction of my result. And after receiving that letter, the opposite part number 3 had corrected my 3 answer sheet of mark. But 1 mark is other than that not corrected, Miller. So that is problem, Miller.
Sorry, sir.
Again and again I have submitted representation and complaint.
Too late. The petitioner claims in the present writ application that he was a student of Sri Jaydev College of Pharmaceutical Science, Naharkanta, Bhubaneswar. First off, he was pursuing his M.Pharma course. M.Pharma course in the year course for the session 2013-2015. First off,
in subject, Miller,
pharmacological spinning methods.
In
subject matter pharmacological spinning methods.
that is not true. He also claims that he had appeared in the examination and had performed well. First off, it is asserted in the writ petition that though that despite his good performance, he was shown absent in the result sheet of first semester examination 2014-15. He approached the college for correction and proper publication of result. Later, a revised result was published in which he was shown present.
Yes, Miller.
In some of the papers. In 2016. He was, however, not satisfied even with the revised result, and he again approached the authorities for further revision. Next, it is the present writ application has been filed seeking direction to the opposite party number 3 for publication of result in farmer first semester bracketed 2014-15. Next, learned counsel appearing on behalf of the petitioner has argued that despite repeated representations, the authorities have not considered his case and published a revised result. Next, we are not inclined to entertain the present writ application on the sole ground of delay and laches on the part of the petitioner. The dispute relates to academic session 2014-15. A revised result was published in 2016 according to the petitioner. It seems that it is the petitioner's own case that 5 years thereafter, for the first time in the year 2021, he made a representation for issuance of a publication of a revised result. And 2 years thereafter, in 2022, he filed another representation by way of reminder. Next, we are of the view that this writ application suffers from delay and laches and deserves to be dismissed on the said ground alone and is accordingly dismissed. Yes.
Item 14.
14. I'm appearing for the opposite party number 2 today. I've prepared my counter If your lordship grants me 1 day, calls this matter day after tomorrow, I'll be in a position to file the counter and lordship may finally hear the matter.
Then senior counsel appearing on behalf of
OJE, Orissa Joint Entrance Examination Committee, opposite party number 2.
Odisha Joint
Entrance Examination Committee.
Examination Committee
My lords,
submits that filing of a counter affidavit on behalf of OGEC. Just bracket kar do, OGEC and then behalf of is underway and is likely to be underway. Word of underway. Underway and it shall be done by a day after by tomorrow.
By day after.
By day after.
So we are for the OP number 3. That is Chairman Ayush Admission Central Council Committee, Ministry of Ayush. So we don't have any instruction. If you keep your to day after tomorrow, it's fine. But ultimately, if my lord will issue notice, then I have to take it.
Let it be done. Stop. Yes, so it's for the petitioner.
Yeah, please, lordship.
He also wants to file counter affidavit.
Okay. I don't have any objection.
Deputy Solicitor General of India accepts notice on behalf of opposite party number 3. Opposite party number 3. Stop. And let requisite number of copies of the writ petition be served upon him by tomorrow. Stop. Just this case on 4 weeks. Stop. Let in the meanwhile a counter affidavit be filed on behalf of opposite party number 3 also. What is this matter about?
Praying that he has already taken admission in a college.
He wants
shifting to Puri. Now, our stand is broadly this, that we have already done, my lords, 2 rounds of counseling officially as per the, my lord, that National Commission for, my lords, I'm sorry, National Commission for Indian System Medicine. There's a time schedule for that. So we had already done 2 rounds of counseling. Thereafter, the National Testing Agency said that no, you do the counseling for the students. So they entered in the 3rd round. So we could only accommodate them from him.
Sweeping. Sweeping thing.
No, the 3rd round, last round. Last round. So last round he had already taken admission. Then he is challenging the spot counseling because our regulation is once a student takes admission somewhere in any of the rounds of counseling, he is thereafter not eligible to come to the spot. Spot is only for left out students. So he wants cancellation of the spot and also he wants us transfer to his preferred college in Puri. Puri was no longer available to him by the time they entered these are all. These facts have to be brought to your lordship's notice on record.
There is nothing, Mr.
Once
Once you have taken admission,
they have not come. They have not followed the rules of.
You consumed the seat.
Sorry, I have already.
It's pursuing also, studying.
Opted as upgradation. I have allowed opted as upgradation. Allowed.
All right, Wills.
They have not conducted the follow of the Ayush admission Central Council Committee rules.
Wills.
Lordship is calling it after
4 weeks.
Great.
Item number 15.
4 weeks.
If I may, Your Lordship. Your Lordship, the present petitioner submitted an online application seeking permission for establishment of a nursing school. Your Lordship, the application was scrutinized and white letter dated 25th of April 2023, some deficiencies were pointed out. Your Lordship, it was also directed to comply with the direction within 2 weeks. The petitioner hardly took 2 weeks, Your Lordship, and by 8th of May 2023, all the documents were enclosed as marked under Annexure 2. Your Lordship, but after that, no communication was made to the petitioner, Your Lordship. regarding the acceptance nor even the refusal, Your Lordship. Lordship, which is a clear violation of section 4 of the Odisha Education Act.
What is that?
Your Lordship, the subsection 4 of the section 4 of Odisha Education Act. Your Lordship, kindly scroll over to page 8. The prescribed authority shall communicate the orders granting permission and recognition to the concerned person or body of persons.
So you want your writ petition to be admitted?
Yes, Your Lordship.
Hmm?
Yes, Your Lordship.
You should admit.
Yeah, what is the practice here? Yes, the
Application.
Yes, Your Lordship.
Yes. Should we admit?
I'm not.
Huh? You are not there, but this question is,
Is this
from
is
all
this
the
to be
members of
admitted?
this question is to all the members of the bar, that whether
I didn't heard what he said.
No, this is establishment of nursing school.
Yes.
Not this is the
Yeah.
Odisha
So-
Education Act is not applicable.
May not be applicable. That act may not be applicable because it's under a special statute.
That is Indian Nursing Council Act and the admission to the nursing courses. Our state council and state examination board conduct the examination. So Education Act doesn't come into.
Your Lordship, see section 3.
why are you relying on this? Section
3 of that education manual, that schools have been defined.
Why are you relying on this, madam?
F, Your Lordship can see 3F.
Yes.
Educational institution means any college or junior college or a higher secondary school or any other school defined in this act or in imparting technical and professional and special includes all moves and so on.
No, your application was made for which academic year?
Your Lordship, 2023 to 24.
And you want a direction for academic year 2024-25.
Yes, Your Lordship. Your Lordship, application was made, but they have not communicated
We
to
will
me.
have to make a fresh application. That is the.
Yes, Your Lordship.
procedure.
I bowed on Your Lordship. But Your Lordship, I just want a direction so that they can communicate to as the prescribed time has gone for the advertisement for the session 2023 to 24. Your Lordship,
So
at least.
this application, in view of the application which you had made, has
Rendered infructuous.
it has become infructuous.
Yes, Your Lordship.
Now, once you make an application for 2024-25, you may come to this court if they, and we are going to lay down some timeline
At least a
for
direction
them to
should be
follow.
made to come to seek the same application for the assessment year
No,
of the
they cannot do it.
24-25.
They cannot do.
Yeah,
What is the practice here?
My lord, last year to 23-24 is over already. But 24-25
No,
the
each
application.
what my lord wants to know whether each year, each academic year will have a separate application.
Yes, my lord. 24-25 separate application is to be invited. That is already been invited. That has been also closed down. Applications
For 24-25
yes,
also.
is closed. Application invitation is closed.
Even for 24-25.
Yes, ma'am. The admission to 23-24 is over. Admission.
No, that we understand. Even for 24-25, it is the date is closed.
Yes, ma'am.
And
And
you
he
have
has
not
not
made any
applied.
application.
As per my instruction, this institution has not applied afresh for 24-25.
Then very difficult, madam.
That is why perhaps she wants the already
if
filed
years.
application to be considered
Yes.
for the purpose of this.
Very difficult.
Your Lordship, even the communication of the refusal will also not made, Your Lordship.
So what? You should
But
have come
you
earlier.
could have applied for the 24-25.
You should have applied. You didn't.
My lord, I am appearing for 2 and 3, for the DMT and also the council. Because I got the copy. I got the instruction. And
Your Lordship, I may apply.
We don't know. If the dates have expired, then you can't do anything. The dates are over, then it is the petitioner's case that it had applied for grant of recognition for running a nursing school
Yes, Your Lordship.
or institution.
yes, ma'am. NOC, my lord, not recognition. NOC.
For
No
grant
objections.
of NOC before the state government for establishing Saraswati School of Nursing at Belgachia, Trisulia, Cuttack for the academic session 2023-2024. So, it is the petitioner's grievance that though the said application was filed in within the stipulated time, the state did not intimate approval or rejection against the said application. Stop. In the it is an admitted fact that the admissions for the academic session 2023-2024 are over. Stop. In the aforesaid background, the petitioner has filed the present writ application seeking a direction to the state DMET.
Yes, sir.
Full form लिखोगे DMET to issue no objection certificate for the academic year 2024-25 based on the application which was made for the academic session 2023-2024. So, based on the instructions received from DMET, Learned Council representing the DMET has submitted that press advertisement was issued inviting press notice was issued inviting applications from the desirous institutions for grant of NOC for the academic session 2024-2025. Stop. He has submitted that the petitioner appears to have not responded to the said notice, and based on the application which was made for the previous financial year, no objection cannot be granted for the academic session 2024-2025. So what is your name?
Lordship Pallavi Mahanti.
Mr. M.S. Pallavi Mahanti, Learned Counsel, appearing on behalf of the petitioner, has very strenuously argued that as the state respondents acted in a very irresponsible manner in not even communicating the rejection for the academic session in relation to grant of NOC for the academic session 2023-24, they are under obligation to consider the said application for the academic session 2024-2025. Stop. Next. we are not convinced with the submission advanced on behalf of the petitioner. We accordingly do not find any merit in the presented application, which is accordingly dismissed. Stop. If, however, the date for filing a date for making application for grant of no objection certificate is extended by the state government in future, the petitioner shall be at liberty to apply afresh.
The extension is given by DMT.
DMT.
Extension is DMT.
Directorate of
Director of Medical Education
and Training.
DMT, yes.
Item number 16.
May please, Your Lordship. Not here the petitioner not had submitted application for grant of India-made foreign liquor on-sub license. Not, that was not inquired into by the Inspector Excise, and they have submitted a report that there is feasible and it may be granted. But however, there is a small private temple is there that can be relaxed by the under Rule 26 of the Odisha Excise Rules, where it provides a relaxation by the government. Accordingly, collector and commissioner both have recommended my case. But the government in a cryptic order has been rejected. That is Annexure 8, page 25, applying that there is policy violation of Excise Policy 23-24. Which clause of the excise policy has been violated has not been stated in the impugned order. And also, we have not been given an opportunity of hearing, and no personal principle of natural justice has been violated. Because
which right did you have? Which right has been violated of yours? There is the question of grant of principles of natural justice.
It has been collector and
something has been cancelled.
It has been rejected.
There is difference between rejection and cancellation. But if something was there with you and that has been snatched, then principles of natural justice will apply. Or there some decision has been taken adverse to your interest, which was which had accrued to you. Then of course,
here it is a we have
question of
before application we are setting up a restaurant. We are running restaurant because the on-shop IMFL on-shop will be granted in a restaurant or in a hotel. So you have not set up.
That has been rejected.
A lot of investment has been.
Let us see the tenor of the letter.
Annexure 8, page 25.
Yes.
But I am directed to invite reference to your letter 11/5/2023, by the application so and so dated 33/23 on the subject cited above, and to say that government, after careful consideration, have been pleased to reject the application for opening of IMFL restaurant on-sub without lodging in favor of so and so place in the name and style roadside bar and restaurant due to violation
Where
of
is your fundamental right or legal right?
under Rule 51 of the Odisha Excise Rules. Odisha Excise Rules, Rule 51. Application. Lordship pays, I think 95, 94 or 95. Lordship got Rule 51.
Yes.
Application for grant of license of foreign liquor or MFL or beer on sub.
No, where is the compulsion for the state to grant you license?
Under these provisions of law 51, it says if somebody submitted an application, it will be scrutinized and public notice inviting objection will be issued. Then collector will decide the objections and anything is there, and he will recommend under Rule 12.
Where is the compulsion on the state government to grant license? Is there any provision that once the collector recommends, the government is bound by such recommendation?
No, that is not the reason in the impugned order. that we are not accepting the recommendation of
All right.
collector.
Yes.
They are saying applying that violation of excise policy.
Yes.
Which clause of the excise policy of the 23-24 they have not stated. There are a lot of clauses are there.
All right. All right.
Number of cases has been admitted, my lord.
No.
And
My friend is,
yes, it was in the
annexed that policy.
yes, I
Yes, I'm saying that you have annexed, I'm saying that. You'll also may kindly come to that policy where it has been listed how it shall be granted, on-sub license shall be granted.
No, but you could have indicated in your letter.
No, relying on the policy only, I have indicated, Milords.
No, but you should have mentioned that because of this policy.
Clause, Milords, in terms of non-mention the particular clause, it's Milords. But we have said that the policy, Milords.
All right, where is the policy?
Yes, Lords, you may come to page 21, Milords.
Yes.
Clause 4.2.3, last clause, Milords. IMFL on-shops and beer parlor. That's got it, Milords.
Yes.
No new application for on-shop license shall be accepted for rural areas in 23-24. It's a rural area, Milords. He has made an application for the session 23-24. And
no, Milord.
If it is urban also, Milords, without Milords lodging facilities, no license can be granted. And his application is without lodging, Milords. Only restaurant. If you also read that, Milord, 4.2.3, no new application for on-shop license shall be accepted for rural areas in 2023-24. In urban areas, new on-shop license can be granted for only star hotels and other hotels having such minimum number of rooms to be decided by the excise department. Here, also may kindly look at his application. It's without lodging facilities, without accommodation, only restaurant. So it cannot be considered, Milords. And furthermore, Milords, it's within the rural area, Milords. It's not an urban area. So in the rural area, no on-shop license can be granted for the Milords session 23-24, Milords.
But here I have submitted an application 22-23. The date of this application is 33-23. And Milord, here the point 4.2.3, which the excise policy they are saying, that also I have challenged in this writ petition, saying that it is contrary to Rule 51. It cannot override the Rule 51. The statutory provisions of law doesn't restrict anything that somebody cannot apply that in rural area or urban area having other hotels and all restaurants. That restriction is nowhere it is stipulated in Rule 51. So this policy, if my friend is arguing that it is not override that statutory rules.
All right. So we are holding that this is permissible. This policy is 24 is over.
No, Lord, it is up to 31st March is there.
So now you cannot open.
It can't. Lordship will set aside this.
No.
Then we can. Lord.
We will hold that. This is
another month is there, about 20. Today is 4th, Lord.
We shall hold.
Yes.
That this policy is in public interest, has rightly been taken, and it does not contravene any of the provisions of the rules or the act.
Rule 53, 51, there is no such restriction.
May not be, but still the government has the power to impose. That power is inherent.
No, state can have the power, but it can't override.
There is no question of overriding. It's a question of exercising power.
Yes.
It is not contrary to any provision. It is laying down some further restrictions that can be done.
No, contrary to Rule 51.
All right.
Contrary to Rule 51, Lordship, there is no such restriction.
All right.
There are a lot of cases has been filed.
We are deciding one of the cases right now.
They have filed counter and we have filed result.
No requirement. We will uphold. This policy, the policy matter. Right.
No, this one court has already, has been admitted, lot of cases, not a
Yes.
single case. In one stroke, they
We
have.
will take up all the
rejected.
cases.
Yes, that taken up day after tomorrow.
No, we will take up, we will pass the order and we will decide other cases.
But your lordship, we have challenged this, particular clause of 4.2.3.
Absolutely, there is nothing wrong at all in that. This thing. Let us see. You are referring to 52.
51, brother.
51.
Lord. Application.
Or 16,000.
Lordship, subject to the provisions of these rules and application of for foreign liquor or MFL or beer on subs shall be submitted in form X1B.
When did you make your application?
On 30th March 2023.
30th March 2023.
Yes.
Under this policy.
Lord. No, the policy came, Lord, 1/4/2023. Prior to Lord, 2 days. The policy came into force.
The scheme was issued on 30. The scheme came on 33. 2023.
33, Lord, effect is from 1/4.
That we understand.
Yes. 33. The policy date is 33/2023, and Lord, that they have issued another letter where they have stated those who have submitted application 2023 that has been extended for 3 months for consideration. Lordship, that I have enclosed also. Lordship, can have glance first to that letter.
Just a minute. So when did you file your writ petition?
Lord, I filed writ petition on 12th February
12th February.
2024.
And when was the rejection order passed?
Rejection order was passed Lord, June 7th June 2023.
So where is the explanation for delay?
Lord, there are other cases were pending, so she couldn't come, the lady. So now she decided and it was filed. Lord, you can glance the government order. Annexure, Lord, 5.
Have you given the details of all such cases?
Yes, this is.
So we will decide this case and judgment will follow in other cases.
Lord, she may fix it to Wednesday because
No, there is nothing.
Because materials have been given in that case, all other cases. Because Lord, they have granted contrary to the policy also.
Mr. Counsel, in any case, it is coming to an end on 31st of March.
Yes, Lord.
So, all right. So if you are compelling us to decide, we will be deciding right now.
No, Lord, I am not compelling, Lord.
Yes, you are compelling.
Lord, what the government has done, I am just, Lord, I am bringing to Lordships.
Yes.
What is the?
So we will decide.
Lordship, can you glance Annexure 5, page 19. That is dated, my Lord, Government of Odisha Excise Department on 27/3/2023.
What 27/3/2023?
They have decided that those applications which are received during.
All right, we have understood.
They have extended, my Lord, to decide those cases. But my Lord, without deciding on merit, they have applied the policy. And though that policy, my Lord, is contrary to Rule 51.
Mr. Counsel, if you make this submission 100 times,
no, Lord.
That will not make your submission stronger.
No, Lord, I am referring to that government letter I said. Not, Lord, I have repeated. To the government letter, I was referring to that.
It's my view. That is a public interest.
Lots you got it. Annexure 5, page 19.
The petitioner.
Lordship may fix it to Wednesday so that
Sorry.
Lord, I will prepare the other cases where Lord the materials are given Lord, because counter rejoinder has been filed.
Sorry.
And
We will not refer to any counter affidavit, any rejoinder affidavit. We will refer to your pleadings and then the petitioner has made an application on 30/3/2023 for grant of India-made foreign liquor license.
Yes.
On shop license. On shop
license.
On shop license for the restaurant for his restaurant, namely MS Roadside Bar and Restaurant, quote unquote, MS, for the financial year,
Excise.
for the excise year 2022-2023.
Milord.
Huh?
Milord. I have applied 22-23.
Then what is?
Milord, that was extended by the government. That is Annexure 5 I was showing Lordships. So that's why Milord, they have the authorities have acted upon
Come
my
to paragraph 3. Please come to paragraph 3.
Paragraph. 22-23, Milord. Once I will apply on 30th means it will be 22-23 because for 2 days left. And since the government has on 27 decided to extend, so my case was considered by the collector and commissioner, excise. Both have decided, as per rule 51, they have decided.
For the excise year 2022-23.
Another submission is there. I have also taken in the ground. The excise policy which they have issued, there is in the act and rules, there is no such provision to frame excise policy by the government. And that if they have issued, that also not gazetted as per rule section 91, it should be gazetted having effect in the eye of law. And that point also I have taken. So, Lordship, that's why I'm telling that other cases that point was taken and that is ready for hearing. Lordship, heard the matter on Wednesday.
I admire your honesty, Mr. Counsel. You are testing our
I'm proceeding, Lord. I'm proceeding, Lord. Because, Lord, we will have to protect our client and we'll pursue the Lordships.
Yes. You can challenge it.
No, I have challenged, Lord. I have challenged.
You can challenge this court's order.
Oh, sorry.
For the... Please take your seat.
Yes.
For IMFL on-shop license for the year 2022-23. Stop. It has been argued that the petitioner was granted license and he was allowed to run on-shop license even after 33/2023. Stop. His application was recommended for grant of license by the collector, recommended by the collector to the state government concerned department for grant of license. Stop. By the state government. Where is the impugned order? Impugned order.
Page 25.
The state government in the Department of Excise Department has, however, by an order dated 6/6/2000, by a letter dated 6/6/2023, addressed to the Excise Commissioner Odisha, has rejected the petitioner's application for grant of license on the ground of violation of existing excise policy for the year 2023 to -24. Unquote. Stop. Learned counsel assailing the impugned order, impugned communication, has submitted that the rejection for grant of license by the impugned order dated 6/6/2023, communicated by memo number 7/6/2023, is in violation of principles of natural justice, inasmuch as the petitioner was not given any opportunity of hearing before such rejection. So he has further submitted that though the impugned communication refers to quote unquote existing excise policy for the year 2023/24, comma, it does not refer as to which clause of the excise policy would have been violated had the license been issued in favor of the petitioner. Stop. It is next. It is pertinent to note that learned counsel appearing on behalf of learned AGA representing the state of Odisha has drawn our attention to the excise policy formulated by the state government of state government of Odisha, dated 30/3/2023, which has been brought on record by way of Annexure 6 to the present writ application, with particular reference to paragraph 4.2.3 thereof, which reads as under page 21. Stop. He submits that 4.2.3 Roman 1. Referring to the said part of the scheme, he has submitted that admittedly the petitioner's application for license pertains to rural area and that too for a restaurant. A shop. In such circumstance, following the excise policy of the state government, the petitioner's application for grant of license has rightly been rejected. Stop. Next, in response to the submission advanced on behalf of the state, and counsel appearing on behalf of the petitioner has submitted that the said excise, that the policy, that clause 4.2.3 bracketed Roman 1 of the excise policy contravenes the statutory provisions under the Odisha Excise Rules 2007 and Odisha Excise Act 2008. Stop. He submits that 2017 Odisha Excise Rules 2017 17 or 8 18 sorry 8. Stop. He submits that the kind of restriction prescribed under clause 4.2.3 bracketed Roman 1 of the excise policy dated 33/2023 is not contemplated under the provisions of the rules of 2017 and the Act of 2008. Stop. Next, after having gone through the pleadings on record and examined the statutory provisions, following facts emerge, colon dash, the petitioner's application was for a place in a rural area. First off, the petitioner was running a restaurant for which he had applied for license for on-shop on-shop, that's called IMFL shop. On shop
restaurant
for IMFL restaurant on shop. So it was the excise department. We do not find any doubt that there is no doubt at all that the decision to decline the petitioner grant of license is in accordance with the excise policy dated 33/2023 for the excise year 2023-24. Stop. Next. We do not find any merit in the submission advanced on behalf of the petitioner that clause 4.2.3 bracketed Roman 1 violates any provision of the rule of 2017 rules of 2017 or the Act of 2008. First off, the provision in the policy that no on-shop license shall be granted in rural area is apparently in public interest. First off, the state government does have jurisdiction to make apposite policy for regulating grant of licenses under the provisions of the Act of 2008 and the Orissa Excise Act and the rules of 2017. First off, the policy of the policy dated 30/3/2023 for the financial year 2023-24 does not suffer from any legal infirmity. First off, in any view of the matter, the term of the policy is coming to an end by 31st of March 2024. Stop. Next, we do not find any merit in this application, which is accordingly dismissed. Give the list.
Not kindly be taken up day after tomorrow.
We will see.
I'm giving the list, Lord, day after tomorrow.
We will see.
Item 17.
On item 17, the judgment out of this present question arises was challenged in Honorable Supreme Court, and the Honorable Supreme Court on 16/2/2024 has been pleased to stay the present question. I have given the order. I have ordered.
Learned counsel appearing on behalf of
Opposite button 4.
opposite party number 4 has informed that this court's order violation of which has been alleged in the present contempt application has been stayed by the Supreme Court by an order dated
16th of February
2024, passed in SLP bracketed civil diary number 49487 of 2023. So, in such view of the matter, no case of willful disobedience of this court's order can be said to be made out. Stop. The contempt proceeding is stopped accordingly.
Okay.
Item 18.
Contempt proceeding is stayed, my lord.
No, contempt proceeding is dropped because as on date they have not committed any offense. After
disposal SLP, he can again renew.
You can do whatever you want. That will depend upon the nature of order.
Item 18.
Number
18.
Yes. Yes,
18 and 19 lots, all similar matters, lots have been pleased to grant me 8 weeks time. We had 28 application, we have to make an inquiry and pass order lots. So here also lots may grant me 8 weeks time, first contempt.
First contempt.
Yes.
All right, 8 weeks. As requested.
Item number 20.
On behalf of State Color.
Item 20C.
Yeah, disposed of matter. And file is not traceable with me. And probably government has.
2007.
Yes, that's a disposed of matter.
Extension of time was sought.
That's probably is filed by
As per-
state.
State has. Yes.
No, as per docket note, extension of time.
For implementation of the final order of the honorable court. That is also filed in 2008.
Yes.
So what is the status? I have to-
Yes, the dispose of has not pressed.
May I pray the lordship may dispose it of by saying that if liberty may be granted to the petitioner, if the order has not been implemented, he can renew the prayer.
That was.
Learned counsel for the petitioner states that he does not have any instructions in the matter. No, stop. Which is IA? IA, is there any IA?
Yes.
There are two IAs.
There are two IAs.
Miscase number.
Yes.
At that time it was
Yes, miscase.
Previously it was miscase.
8729.
M7,
8729 and
8739.
872, Miss
I think
MC number.
they have another miscase also.
8729, 8739 of 2000.
Another is 15976 of 2008.
All of them can be disposed of.
All the miscellaneous cases stand disposed of with all miscellaneous cases not already disposed of stand disposed of as not pressed for the present with a liberty to the petitioner to approach the court if required, if situation so warrants.
Yes.
Obliged.
Item 21.
Those petition was filed by the opposite parties for compliance. That is already compliant.
It is stated by London Senior Counsel appearing on behalf of the petitioner that this court's order has been complied with. IA number? What is that? Something. Which is the application?
Miscase number 7214.
Another miscase is also.
Another also.
14268 of 2010.
My lord.
Both
Flag B.
main order has been complied already, carried out. Order of the
IA
petition
number.
has already been carried out as per main instruction.
IN number 1427, 1428/10 stands disposed of accordingly.
The petition also accepts the compliance. Each
Yes,
petition.
Item 22.
This matter, may I humbly pray one thing, your lordship may kindly grant me 1 week time to take fresh steps.
Fresh steps.
For notice against OP number 4.
Let me see. Which item?
22.
22.
Wow. This is 2012.
Yes.
What will you do now?
Contractual
dispute, lordship.
No.
Paragraph 12, lordship.
What has happened, my lord?
Page 5.
The council Abhay Charan Jana who are doing the matter, my lord, dealing with, he is no more. And I got yesterday the file. My lord, I would address your lordship if notice is not necessary. I would address the notice or I would take
No,
out
let us
notice.
see what is the relief.
My lord,
Who gave you the file?
Petitioner has already invoked the arbitration clause, lordship.
no,
Para 12, page 5, lordship.
already invoked, my lord.
Then
And I will-
Dispute, lordship.
No, not whether I have taken a ground, what I was often on seeing the file, because that arbitration clause is there, but he has not availed that. But my learned friend is saying that he has already availed. So I have to take for 3 to 4 days time to pray for that. The council is dead, minor SCJ na. And he was entrusted the file to me, it was with him, and yesterday I got it. Lordship, if notice is not necessary, taking notice to OP number 4, I will not file requisites. Or your lordship may kindly grant me time, I would file the requisites within 1 week. Thereafter, by the next date, my lord, it would be hard, my lord. I would address your lordship, my lord. Council is no more, but difficult position for me. Lordship may kindly consider.
As requested on behalf of the petitioner, list this matter on Tuesday next.
I am appearing for OP1, lordship.
My lord, I would file the requisites if your lordship would permit.
No, don't do.
On the merit of the case.
Well, it has been pointed out by learned counsel representing the estate that the petitioner has already invoked the arbitration clause.
And there is no prayer against the state, lordship. This is a private party dispute. So prayer, lordship, is against opposite party number 2. The dispute is between petitioner along with and the opposite party number 2. State has no role with the
You are additional standing counsel for opposite party number 1.
Yes.
Commissioner, deputy commissioner. You have no role.
No, man. Prayer, lordship, can you see the prayer?
No, but you know that this has happened.
No, the petitioner has contended in para 12, lordship, that it's an interstate dispute and the petitioner has already invoked the arbitration and for that cause of action, petitioner has filed this state petition. And the prayer is to release the amount from the opposite party number 2, lordship. Release the withheld amount from the opposite party number 2, lordship. And the opposite party
How is this writ application maintainable?
That's any order can be passed for 1 week time. I would verify. I got the file yesterday.
All right.
The council has done.
We have granted.
May I humble pray? Because of the fasting this week, I will go to my native village. Your lordship is posting to Tuesday. Maybe 2 days after my lord, Thursday. Tuesday next year, lordship. Yes, obliged one.
P3.
In this case, in the final order, your lordship has directed the member board of revenue to dispose of the appeal within a particular period. And we have filed an application for extension of that. That was not disposed of. Notice has already been sent to all the respondents there and they have appeared. Now,
So where is your application?
Yes, that is.
Flag B.
23.
16971 up to 23. Flag B.
Yeah, flag B.
How much time did you require?
Actually, I had prayed for 3 weeks time, but in the meanwhile, 3 weeks already expired. Your lordship may
So
fix it.
you have got the time extended.
May give me some more time because the
More.
member transferred in the meanwhile. The member board of revenue transferred in the meanwhile.
Sorry, limit. We are just disposing it off.
By the end of May, we will dispose.
No. They wanted 3 weeks time. The time is over.
You don't have any further instruction.
As on date, what is the status? I have to get the instruction because the
Tomorrow. Tomorrow, tell us.
tomorrow.
Yes. Tomorrow.
Item 24.
You draw the case. It has not been disposed of. Oh.
Item 25.
My lord, here the delay of 97 days on which my lord issued notice.
And my lord, we have filed our objection, my lord.
Yes, 97 is waiting for this.
My lord.
State of Orissa is very kind to you. They have filed the appeal within less than 100 days. So that should be condoned.
Yes, my lord. Delay may be condoned, matter may be hard on merit.
Yes, please.
Obliged.
Are you?
Well, I am the respondent, my lord.
The
state is the appellant, my lord.
My lord, I have a very short point for appreciation of this honorable court. The order is at page 46 now. The order impugned before this honorable court. Page 46 now.
Yes.
My lord, sir, page 46. My lord, here, before I take my lords to the judgment, the fact, undisputed fact is the post is laboratory assistant nurse. Now, my lord, kindly note that this laboratory assistant has two qualifications. One is intermediate qualification and one is the BSc qualification. For intermediate qualification, there is a scale of pay. For BSc qualification, there is a scale. These are not disputed now. The next point is, my lord, the petitioner has BSc qualification. Now, petitioner prayed before this honorable court for grant of that scale of pay. Only thing, my lord, which my most humble submission, the honorable court lost sight of is that the post was created with the lesser scale of pay. So, yes, we admit you are entitled to BSc scale of pay, the higher scale. But if the post against which you are appointed was created with lesser scale of pay, that is intermediate, and you have joined having BSc, you had BSc by that time. He had BSc by that time. He had the higher qualification. But the post against which he was appointed, my lord, was the intermediate qualification. With that, it was created. That is one line case before this honorable court.
So there are how many posts?
One post, my lord. Because you are the post against which he was appointed. I'm sorry.
How do you say this? How do you make this submission that that post was for intermediate?
Yes. For that, may I take my lord to page 2 of my count?
No.
That was the specific stand before this honorable.
No. Whether it was there in the advertisement, there must have been some advertisement.
Advertisement was not annexed by him. Also, we have also not done that. But before this honorable court, in a counter affidavit, he clearly said that this post was created with this scale of pay.
Whether it was made known to him.
Again?
Whether it was made known to him that this post, you are having BSc qualification, but this post is for ISC, this thing, pay scale.
My lord,
if a person applies against a post, he has a right to know he is applying against what? The status, the pay scale, everything. So what was there in the advertisement? If you file counter affidavit, then you could have, you don't know whether you had taken this plea or not.
Well, will my lord kindly see for a moment? My lords have that, it is in my lord's record. If my lord's the counter in way number 343.
All right. Let us see where is this provision that ISC will get this scale and PSC will get this that.
No, that is all. My lords have already in if my lord is holding it holding page 46.
No, forget the order.
No.
Where is your scheme?
That scheme has been my lord described in the counter.
Describe will not.
My lord is asking about document.
You take us to document and his application or appointment letter, whatever.
Those documents, neither my lord, he has not annexed nor also.
But he said with the eyes open, he has accepted.
Yes, that is the case.
So show that document which you have given to him. On that basis, he joined. unless that comes out,
Yes,
we can't come to positive finding,
well,
or we cannot say that this learned single judge has made
well,
some error.
only one paragraph I will read. If my notes are not convinced, I will come out with an affidavit. to
Unless you show that prima facie or apparent flaw
I understand.
in coming to this conclusion.
That actually those documents are not there before my notes. May I read only one paragraph, subject to my notes,
Yes, what is that?
my lord, I am reading para 2
Of?
page 2 of my counter before the tribunal.
Before the tribunal?
My lord.
The tribunal
Then subsequently it was transferred to this honorable court because of abolition.
Counter. And that brief explains here.
No, which item is this?
25.
25, this is writ appeal.
Well,
With writ appeal, another file is that. That is WPC OAC.
So how that touch? Understood.
Page 34.
Yes.
Well, I'm reading para 2, man. That as regards to the amendment made in para 6.4 of the original application, it is humbly submitted that since the post of laboratory assistant in different engineering schools and polytechnics.
Which paragraph you are reading?
Well, para 2 I am reading. If my notes have got the counter, page 2 of that counter. Internal page 2 of that counter, para 2.
Page 35.
May I read now? Well, that as regards to the amendments made in para 6.4 of the original application, it is humbly submitted that since the post of laboratory assistant in different engineering schools and polytechnics under the control of directorate had been created by government in industries department in the scale of pay of rupees 320 to 550, having intermediate as entry qualification, the applicant, although possessed higher qualification at the entry level, was appointed in the above said post with a scale of pay prescribed by government by the GO. So granting of higher scale of pay to the applicant Gopinath Mayor by the respondent as per FDOM 24/12/86 under Annex 3 is not tenable in the eye of law. Now, to the my lord's query that the documents of that post and his application, that my lord may give me 7 days time, I will produce by way of an application for better appreciation of this honorable. This is only.
Lordship, kindly have a glance at the judgment passed by the Honorable Single Judge, my lord. That is, Lordship may come to the operative part of the judgment, my lord. Page 51, my lord. Para 12, my lord.
You have enclosed to your writ petition, Annexure 1, page 8. That is your appointment order.
Yes, my lord. Lordship, for a moment, kindly have a glance at the judgment passed by the learned single judgment. Having heard learned counsel for the parties and considering the matter.
Let us see your appointment letter also.
Yes, my lord. Well, I have annexed that in the counter affidavit filed by me, my lord.
Not counter, in your original application itself, Annexure 1.
Yes, my lord.
That shows your appointment letter.
Yes, my lord. Sri Gopinath Mayor is appointed temporarily in the post of laboratory assistant, the pay of rupees 840 per month in the scale of pay of 840. That is not.
So where is there any recruitment rule? Is there any rule or is there something specifying qualification?
Well, the rules came much after that. At the time of his joining, there was no recruitment.
How do you say that there were two scales for ISC and BSc?
That was prevailing.
Huh?
That was prevailing for BSc qualification.
Where is that?
My lord, I have annexed, my lord. My lord, lordship, I have filed a counter.
Annex 3, page
Yes,
12.
page 15. I have filed a preliminary counter affidavit.
In the appeal?
Yes, my lord. Page 15. Annex D by 1, my lord.
Page 15.
Yes, my lord. Annex D by 1, page 15.
Page 12. Yep. ISC and BSc, two different categories.
Page 12 of what? Page 12 of writ appeal.
Annual increment. Mr. Mishra, you have page 12 of the original application.
When were you appointed? When was he appointed?
My lord, I was appointed on
1990.
yes, my lord, 1990.
Yes, so office memorandum in respect of annual increment.
86.
Annex 3.
Yes.
That brings out distinction between minimum entry qualification for direct recruitment to this grade should be BSc with training.
Well,
Then another one, intermediate science with training.
minimum entry qualification for direct recruitment to the grade should be intermediate in science with training or particular 2 years training.
So it cannot be your case that suppose there were 20 posts, posts of laboratory assistant. 10 were for ISC qualified and 10 were for BSc qualified. Is this your case?
Yes, Malord. Because Malord will appreciate what it because Malord, this is only one scale. But why you have come up in appeal is in that engineering school, one laboratory assistant is there. In all over Odisha, there are 20 or 30 laboratory assistants. But it's not in one place. In different schools, we have one.
No, but when we see this, it is clear from this, your annexure 3 of the writ petition.
Malord. Yes, my lord, that is not disputed because for the BSc qualification, he is entitled to
anyone who is holding the post of laboratory assistant, if he or she has BSc qualification, he will be entitled for that scale, and those having ISc qualification will be entitled for a different scale. This is what can be seen from this notification, this resolution.
With only one line, subject to my lord's acceptance. Yes, absolutely correct, my lord. Subject to that, he is holding that. Suppose, my lord, we have created 10 posts of
creation, they cannot enter into the creation. When was the post created? What is there in your file? That is different. But here, this is your policy of 1986. And the policy is very clear.
My lord, not this one.
And appointment letter has not also brought out any invidious distinction between BSc or ISc. The appointment letter, there is no distinction.
Right, my lord. But my lord knows, that a post, a scale of pay is attached to a postman. That's my humble submission. I am not trying, I am not saying that, yes, that's why I said these are undisputed. But a post carries a scale, madam. So, merely because you possess higher qualification, if you are appointed against a post carrying a particular scale of pay, you won't automatically get it, madam.
Yes.
I can give an affidavit before this honorable court with the creation letter.
Creation, we shall not go into that.
No. The appointment order itself also he is governed by that.
Yes, in the appointment letter, there is nothing.
Well, there is scale mentioned, 840. That is the scale which is 320 to 450 scale is the revised of 840.
All right. We will not.
That was only the submission, my lord, or the distinction. Otherwise, because unless that was my endeavor before this honorable court, that yes, if you have to get to a particular post to get that particular scale attached to that. My lord will allow me to file an affidavit?
No. They're discussing it. The state of Odisha has preferred this intra-court appeal, putting to challenge a judgment dated 25/2022 rendered by a learned single judge of this court in WPC within bracket OAC number 3436 of 2013 bracketed Gopinath Meher versus State of Odisha and others, whereby the learned single judge has allowed the petitioners allowed the writ application filed by the sole respondent holding that he was entitled to the scale of pay which pay available to a laboratory assistant with BSc qualification. BSc training qualification laboratory assistant where?
He was posted.
Jharsuguda Engineering School, Jharsuguda.
Jharsuguda Engineering School, Jharsuguda.
In an engineering school.
Yes, ma'am.
Proper. Next. Learned AGA representing the state of Bihar has submitted
The state of
the
Odisha.
fact that the respondent held BSc qualification with training as on the date of his appointment as laboratory assistant is not in dispute.
Yes.
So he has, however, submitted. He also submits that it is also not in dispute that there are two scales available for the employees occupying for the laboratory assistants, one having qualification of ISC training and the other, comma, BSc training. So he, however, submits, he submits that the petitioner's appointment, that the appointment of the respondent, sole respondent, was against the post of laboratory assistant with ISC scale. Also, he has further submitted that a specific plea was taken in the counter affidavit filed on behalf of the estate before the tribunal, before the state administrative tribunal, when the matter was pending there, to the effect that scale of ISC respondent was appointed held the scale of ISC trade. So he submits that this crucial aspect has not been duly taken note of by the learned single judge, and therefore the learned single judge has committed an error of fact while holding the respondent entitled for the scale available to laboratory assistant BSc trained. So stop. Next. Learned counsel appearing on behalf of the respondent has submitted, while defending the decision of learned single judge, has submitted that after taking into account the pleadings / counter pleadings, the learned single judge has held the petitioner entitled to higher scale of laboratory assistant BSc. Stop. Learned single judge, comma, he contains, comma, has rightly held that the petitioner was wrongly given the scale available to the post of laboratory assistant ISC at the time of his appointment.
Yes, yes, my lord.
So stop. Next. We have just a specific. We have heard learned counsel. We have perused the pleadings on record, and we have given our thoughtful consideration to the rival submissions advanced on behalf of the parties. Stop. We consider it profitable to refer to that the government decision finance report.
Answer 3.
Refer to an office memorandum dated 24. What is that?
1986.
24 what?
2410.
2410.
No.
2410.
1086.
86.
Yes.
Which?
Memo it can.
Huh?
In the memo it is there. 24.
Which?
which relates to grant of annual increment to laboratory technician oblique laboratory assistants. First off, we and quote relevant part thereof. इसमें prior to से शुरू करके deleted कर stop. It is evident from the said memorandum, office memorandum issued by office memorandum dated 24/10/1986 that it was decided to grant two different scales for laboratory assistants holding the qualification of BSc training and ISc training. First off, the intention on behalf of the state that the petitioner's appointment was against a post which was created against a post of laboratory assistant which was created for ISc trained only is not supported by any document available on record. Is there any document? No. No. Record. Stop.
Except the appointment. Except the appointment order.
Except
Appointment order.
the appointment
Yes.
later. Except the appointment later of the. No, that does not indicate that the post was created.
It gives a scale of payment.
Scale it says, but it doesn't say that the post was created.
No.
So
So that
the-
scale. So that
the appointment later, however, displays the scale appointment later of the petitioner against the post of laboratory assistant indicates that he was given scale of ISc trained, though he had the qualification of BSc. First off, that was, in fact, the petitioner's grievance before the tribunal and before the writ court. So stop. Mentioning of lower pay scale, the appointment later than what the petitioner was actually entitled to does not indicate that it cannot be said to be an evidence to show that the said post was created with ISc qualification. First off, in any view of the matter, in view of the memorandum of the state government and the state government has noted above, and the fact that a learned single judge of this court has taken a view that the petitioner is entitled for has taken a view. We do not find any
legal infirmity in the impugned judgment rendered by the learned single judge. Full stop. We do not consider it desirable to entertain the challenge to the decision of learned single judge in the present intra-court appeal. First off, this appeal is accordingly dismissed. Orders as to cost.
May I say two lines? My lord, declared state of here, it will be state of Odisha.
State of Bihar only.
And another one line, my lord. My lords have allowed, I don't have any grievance.
No, we have dismissed.
My lords have allowed his claim.
No, we have dismissed your appeal.
Yes, dismissed my claim, allowed his claim.
Yes.
So, my lord, only one. Appointment was in 90. He comes to the tribunal in 2013. At least for that, let it be restricted to three years as observed by the Honorable Chief Justice. Financial position.
Item 26. 26.
Yes.
Order upon a single judge at annexed page 7, my lord. None has appeared for the appellant. I am for respondent.
Are you interested?
No, petitioner was also not present before the learned single judge. That was an expert. None appears for the petitioner at the time of call.
There is no representation on behalf of the appellant. Let's discuss tomorrow.
Item 27.
Tomorrow we shall discuss if it doesn't appear.
My lords, we have a peculiar problem here, my lord. My lords have been pleased to issue notice on 11/5/23. Now, my lord, kindly, I have filed an IA. Now, the problem we are facing, my lord, kindly come to the order. At page 22. My lord, sir.
Yes. Yes.
My lords will see as many as 31 petitioners came together to file this joint application. We have that my lord will decide whether the intra-court appeal is justified or not. But the problem here, my lord, may kindly see how they have been described. Only name, son of. Now, my lord, we can't change because it will, my lord knows it will be, it will immediately also defect if we change the cost act because it's an inter-court appeal. Now, though my lords have issued notice, we are not able to. This is one, my lord. And another appeal is 852, where 945 persons came together. 945 persons, my lord, exactly the similar way. And it's only named son of. So, my lord, I have prayed. I'm not praying that my lord should stay the content proceeding. Or what I am praying, my lord may allow me kindly to serve the notice on the lawyer who is appearing for them in the contempt.
Item number 47.
And that the other writ appeal is also, my lord, 853, that has not come. I will also pray to that to be taken up. My lord, sir, seeing page 21, 22. Here, my lord, 31 petition. In W 850 to 945 petition.
All were under work charge establishment.
Yes, my lord. Now,
So
because we are carrying, so notice is to be served on them.
Through executive engineer, you can, because they were under executive engineer, can't he?
Well, we are to where do we serve them? And with my lord, with great respect, my lord knows such description of cost actually could not have been entertained.
But you should have raised objection there.
My lord, it was disposed of, my lord, the same order. My lord, I will not go to the
Come to the original application.
My lord.
All the petitioners had given their address, a common address.
Through executive engineer. Applicants 1 to 31 are presently working under the work charge establishment executive engineer head.
No, come to the cause title. Their names.
Correspondence.
Paragraph 1.
For correspondence. Address for correspondence.
Address for service of notices.
Yes, ma'am. That's what I am praying. My lord, may allow me to kindly do that. I will serve notice. I will give the notice to the concerned lawyer. That is why I email. Unless I serve it, my lord cannot hear me.
Because the original application itself contains that.
And once I go to that law, he will appearing. He will say, no, I have no instruction, I cannot appear. But he is pursuing the contempt. I am not praying that my lord should stay. I am trying to get this case to be heard.
So has anyone filed any contempt application?
Yes, my lord.
Where is?
Contempt is pending before the honorable single bench.
Bring the lawyer here. Whosoever presses the contempt application, bring him here. Yes.
My lord, may kindly take it up day after tomorrow.
Yes.
My lord, may kindly take up this matter along with WA number 853 of 23 day after, so that I will inform the London Council to be here.
He may not come. In the 28, 27. In the present intra-court appeal, the state of Odisha has put to challenge an order dated 17/11/2021 passed in WPC bracketed OSC number 2619 of 2001. Next. Notices are directed to be issued.
On 11/5/23.
learned AGA, appearing on behalf of the appellant, has submitted that notices were directed to be issued by this court by an order dated 11/5/2023 upon the respondents who were the applicants before the tribunal and writ petitioners before the learned single judge. He further submits that it is impossible to effect service of notices upon the respondents as their addresses are unknown and are not mentioned and were not mentioned in paragraph 1.
In the cost title?
No, there they say paragraph 1 in the tribunal.
Yes, madam, paragraph 1.
In paragraph 1 of the application before the Odisha State Tribunal.
Odisha Administrative Tribunal, Cuttack Bench.
Odisha State Administrative Tribunal, Cuttack Bench, nor the addresses were furnished when the writ proceeding was heard or stopped. He has submitted that because of the absence of the addresses, notices have not been served upon them. Stop. Next. After having perused, he has also submitted that the respondents have filed contempt petition. Petition or petitions? Contempt petition.
Contempt petition.
Petition. So stop. Next. We are satisfied after having seen the cause title of the case that the addresses of the respondents were not supplied. So stop. In paragraph 1 of the application before the tribunal, the address of service of all notices has been mentioned as court, care of Viswajit Mohanty, -1, advocate, Satya Smriti.
Malord, may ignore that. The present lawyer, Malord.
President Espatro.
Yes, sir.
But what is his address?
He is appearing in the content. He is appearing in the content.
Junior. Is junior.
Sadasiv Patra.
So,
No, I have other. Let us see.
Let us go on this.
Don't call. Don't call. Don't call. Stop. He has submitted. It in the facts and circumstances of the case, we direct that since the respondents are pressing their contempt application, and because of absence of addresses, notices in the present appeal cannot be served upon them, comma, we direct that operation of the order which is impugned in the present appeal shall remain stayed. Stop. The respondents who learned counsel for the respondent, learned counsel who is expressing the contempt application for the respondents shall be at liberty to approach the court for vacating the order of stay.
Most obliged.
Item number 28.
In 28, there is a delay of 189 days.
Hmm?
In 28, there is a delay of 189 days. So notice to go.
Right?
Notice has not been issued.
What is your case?
The case, my lord, you also can find it from.
Why should we condone the delay?
It's a case, my lord, the dismissal from service.
Yes.
That dismissal was in the disciplinary proceeding, he was dismissed from service. That the appellate authority has considered his case and converted it to compulsory retirement. Honorable single judge had directed to reinstate him with all service benefits.
Rightly.
Not, my lord, you'll also see page 19, my lord. The only finding is that since one Ashok Kumar Malik, who stand on similar footing, he has been allowed to continue, so this man should be allowed to continue. So he stands on a different footing. I have annexed all the inquiry reports in respect of 3 persons. The applicant and 2 others, all are police constables, and they are allowed to be involved in a gang rape case.
So how do you distinguish?
Yes, my lord, that
case of this petitioner and
yes, my lord, that
this respondent and others?
yes, my lord, you'll also turn to page 22, annexure 2. This was the inquiry report in respect of Ashok Kumar Malik.
And what about others?
Yes, I have annexed the
All are acquitted. All are acquitted.
all are acquitted. But you'll also in the departmental proceeding, you'll also see that the inquiry report in respect of Ashok Kumar Malik, I will drop my lord's notice only page.
And where is the inquiry report in case of other 2?
Yes, my lord, they have, in that departmental proceeding, in the inquiry report, they are found guilty.
So they were also found guilty.
They were found, this Ashok Kumar Malik was not found guilty, but in respect of Pratap Kumar Sahu and this Kailash Chandra Kandi, they were found guilty, and Kailash Chandra Kandi and Pratap Kumar Sahu were dismissed from service. Both are dismissed from service. Since this Ashok Kumar Malik was not found guilty, so we are not dismissed from service. That is the distinction.
Who are 3 persons? Who are the 3 persons?
Ashok Kumar Malik,
Ashok Kumar Malik,
Kailash Kumar Kandi,
huh?
Kailash Kumar Kandi, the present respondent?
Kailash.
Milo. And Pratap Kumar
Just
Behera.
a minute, there are Kailash Kumar Kandi and
Pratap Kumar Behera. Pratap Kumar Behera, Milo.
Pratap.
Pratap Kumar Behra.
Kumar Behra. There were three persons
Milo.
against whom criminal cases were launched.
Criminal cases were.
All of them were acquitted in the criminal case.
Yes, Mal. But in the departmental proceeding, one was not found guilty. Why he was not found guilty? Your Lordship can find
Who was
it.
not found guilty?
Ashok Kumar Malik.
Ashok Kumar Malik.
Mal.
So why forget why?
Your Lordship can, yes, my page 24.
Forget why? He has been exonerated.
In the departmental proceeding.
In the departmental proceeding. What happened with them, these two?
They were dismissed from service.
They were dismissed from service.
By the disciplinary authority.
What is the name of the respondent here?
Kailash Kumar Kandi.
Kailash Kumar Kandi is the respondent.
Mal.
What was the case of this? Pratap Kumar Behra?
He was also dismissed from service.
Then what happened?
In that case, my Lord, Kailash Kumar Kandi preferred an appeal. Appeal was rejected. But in review petition, that dismissal order was converted to compulsory retirement.
You do this also?
Yes, this man has been compulsory retired. This man has been, that Kailash Kumar Kandi has been compulsory retired from service.
Yes.
And
But learned single judge has
allowed that
applied Malik's case.
Malik's, yes. So there is a distinction. He cannot stand on the same footing. And in that, very interestingly, my Lord, that in Pratap Kumar Behera case, Honorable Single Judge also directed to give him compulsory retirement in accordance with that Kailash Chandra Kandi case.
No.
In the inquiry, it was found that Malik was not present on that.
Yes, Malik.
That is why benefit of doubt was
yes,
given.
He was not present. He was on. He
report.
Was not found. So for that reason, he was not found guilty in that departmental proceeding.
In the inquiry itself.
Yes. Only that is the distinction, because he cannot stand on the same footing with Ashok Kumar Malik.
No, he cannot claim that.
Yes, but Honorable Single Judge has directed the.
Notice. Issue notice. Any interim order?
Yes, well, stay of that judgment, because there is a contempt.
Learned Counsel for the appellate state of Odisha has submitted that that by the impugned order, the learned single judge has directed a reinstatement of the respondent in service on the ground that one A.K. Malik, against whom also departmental proceeding was initiated with the respondent, came to be exonerated of the charge. So he submits that A.K. Malik was exonerated of the charge based on the evidence available in the departmental inquiry. Because of absence of evidence against him in support of the charge in the departmental inquiry. Well, the case of the respondent cannot be said to be at par with that of A.K. Malik.
Yes, ma'am.
So, after having gone through the pleadings on record and the order and the challenge in the present intra-court appeal, we find, though tentatively,
comma, substance in submission, in the submission advanced on behalf of the appellant. Stop accordingly. The impugned order dated 10/5.
My lord.
2023 passed in WPC bracketed OSC number 2836 of 2014 shall remain state till further orders.
Obliged.
Stop. The respondent number 2.
My lord. Respondent one.
The respondent.
One, only one respondent.
The respondent shall be at liberty to apply for vacating the present order of stay.
Item number 30. So 29, item 29.
29, my lord. I am appearing for the respondent. Then there is a delay, my lord. Your lordship direct to serve me a copy for delay. I file the objection and put up this matter next week.
In the other case, it was under order. We have admitted, we have issued notice, but IAs are pending. Item 28, no?
28, 28.
You are pressing 28, no?
No, 29.
Kailash Chandra Kandi case is item 28. In 28, 2 IAs are there.
One for dispensing with and another for limitation.
Condonation of delay.
Yes.
So we should issue notice on condonation. How many days delay?
189. 189 days.
89 days.
So we cannot pass an order of stay.
So from the beginning, I was mentioning that.
No, that is our mistake.
No, that's.
Order pura card issue notice on the point of limitation.
Yes, ma'am.
You can IA number so and so for exemption allowed.
Well,
notice in IA.
29.
29, well, I am appearing for the respondents. There is a limitation of condonation of delay. Your lordship direct my senior to serve me a copy. I file objection and your lordship put up this matter next week, any day, madam.
Serve a copy. Get a copy of the.
No, I have already served.
No.
Bring next week. Then I will serve it in course.
Get a copy of the limitation application be served upon learned counsel for the respondent by tomorrow. Let's to case 2 weeks so as to learned counsel for the respondent to respond to this limitation application.
Admission item 30.
Item 26. I'm the appellant. 17 days delay. I'm the appellant.
Coming tomorrow.
Praying for pension.
You are not here.
No, my lord.
Will come tomorrow.
Item 30.
Year-old matter and relating to a dispute with regard to settlement of a piece of land in the name of the petitioner under the OE Act, Orissa State Abolition Act.
I was in fact trying to get that act. I could not.
Ladies.
OEA Act.
My lord may fix it to any day or because it has to be heard at length.
It has been heard extensively in several benches.
Yes.
And there is also my written note of submission is available. And I have also given a compilation.
Speaking for myself, I am of the view that they should go before involve disputed questions of title.
The assigned bench.
File a suit.
No, my lord. Here is a suit
They
was
have
filed.
filed the suit and suit was dismissed.
No.
Thereafter, they have filed.
The suit was filed. Suit was dismissed on the ground that the civil court had no jurisdiction to touch that order. Thereafter, we approached this honorable court, my lord, because it is a settlement under the lease principle and it is not coming under the State Abolition Act. So therefore, the civil court held that I have no jurisdiction to touch that order. And it is a order which I have challenged in this writ petition, is an order passed by the member board of revenue by exercising the power under section 38B of the OE Act. And the settlement which has been made, it is made in the name of the intermediary. The intermediary was in khas possession before the pre-vesting stage. It was recorded. There is no dispute about that. This property, this is a part of the Bahal estate. And it was recorded in the name of Nityananda Bharati. It was recorded in the name of Krishna Chandra Bharati, the father of Nityananda Bharati. And he had 6 ana interest. There is no dispute. And in the order of reference, the collector has admitted all these things. And when it was recorded as such, the estate was vested to the state. So therefore, there is a statutory recognition under the OE Act. If a person is continuing as the intermediary, he can retain 33 acres of land with his khas possession. If he is in khas possession, then after the vesting, thereafter, there is a deemed settlement in the name of the intermediary. That is under section by operation of 6 and 7 of the OE Act. So therefore, it was found that he is in possession. He is in khas possession over the land. So therefore, it is a statutory settlement. And it has to be made under section 6 and 7 of the OE Act. A certain limitation was provided.
You are vendee.
I am the vendee from the purchaser of, I am the vendee from the intermediary in whose favor the land was settled. So therefore, the property was settled, that should be, the application should be made within 1 year. And if the 1 year, the application is not made under section 6 and 7, therefore the large number of intermediaries had not made their application. So therefore, government introduced a GO in 2364 by granting privilege to all these left out intermediaries to file their application. And that should be considered under that government order. That is on 2364. And what should be the method of settlement? What should the procedure to be adopted for settlement? 3 years rent as a salami will be calculated from them, will be realized from them with equitable rent and salami. That is the method of settlement. So therefore, it's 1971 he made this application and it was inquired into, and the OA collector accepted that he was in 33 acres of land is in possession. Out of that, 30 acres was settled in his name as the intermediary by fixing the salami and the rent. So far as the settlement under the Act is concerned, no salami is contemplated.
Sir,
I will take
this is a 2000 matter.
2000 matter.
Pending for last 24 years.
24 years because I have no, because it was heard by several benches.
We can understand. Yes. So, this matter will have to be decided.
Yes, have to be decided finally. And by operation of law, he has acquired the Sthitivan right over the property.
We'll see.
If your lordship will fix a particular date at that time, you can place the case because it will take some time.
That will
and
be
only 2-3 points which I want to raise. My learned friend has relied upon the civil suit decision. In that civil suit decision, the Honorable Civil Judge has categorically held the plaintiff, who is the petitioner before your lordship, has no right.
I will answer that question.
Over this. Just 1 minute.
Yes.
And this registered sale deed basing on which he has purchased the land from the so-called ex-intermediary, that is found to be invalid by the civil court. And if your lordship will see, that civil court judgment has not been challenged, and that is a final and conclusive judgment. And so far as this particular suit land is concerned, your lordship may kindly appreciate this is 30 acres of land in that where the CDA sector area is now operating, and it is already handed over to CDA by virtue of a land acquisition, by virtue of a government notification, and CDA has.
That part is not very.
Yes, that we have also mentioned in our counter affidavit, and the CDA is.
Government has not filed any counter.
That is also there in the record.
There the CDA has filed the counter.
CDA has filed the counter.
You have not filed it.
CDA is also.
In spite of several directions, the government has not filed any counter.
That is there is the Board of Except certiorari, the.
Yes,
Board of
it is a
Revenue has
certiorari proceeding. It will be
everything in
decided
the
on
impugned
count
order.
of law.
In the impugned order. And the CDA has filed the counter. CDA is our body.
Who is CDA?
Kotak Development
So
Authority.
where is someone is appearing?
Yes.
Yes.
So when should we fix? Which date?
Let's
We'll fix it 4 weeks.
4 weeks. Why 4 weeks? Should it 2 weeks time, lad, any date. Within 2 weeks, any date. But so far as that my learned friend is submitting that the civil court has held this. Once the civil court has come to the finding that I have no jurisdiction, whatever finding has been arrived at by the civil court.
You made certain preliminary remarks. You know that we are not hearing the matter finally today.
Yes.
He also made certain remarks.
Only for that reason I have, because there is the issue has been framed.
Yeah, let's fix up a date, any day. Last is coming.
18th.
18th. Yes.
18th of this March.
18th of March. 2 p.m.
Yes, please.
Please prepare this thing. I have seen the notes which you have prepared. You also.
My note is also there. This on the.
I have given a preliminary note, thereafter an additional note also, meeting all the points which they have
Let us
raised.
try.
Yes.
Lordship may kindly also have a glance on.
It is very embarrassing for us also to see that a matter of 2000 is still pending.
Item number 31.
31, my lord. I have filed the excuse for
Be allowed.
Yes, sir. May I please, your lordship? I have filed a miscase for amendment of the cost title matter. IA number 15320 of 2023, madam. And the OP number 2 has been redesignated as under secretary instead of assistant secretary. So it should be changed. For cost title should be changed, madam.
OP number 2.
Yes, madam.
Who is OP number 2?
Sorry, petition number 2, madam. Petition number 2. Assistant Director, Aviation Research Center. That should be under secretary.
That doesn't matter. Why?
But I have filed, madam.
Oh.
At the time of filing, he was there, that post was there. And he is in the representative capacity, I think. Union of India is already there. Union of India is already there.
Yes, madam.
As opposite party number 1.
I have already filed the consolidated cost title also.
You have filed already.
Yes, madam.
What is the material?
The IA number 15320 of 2023. They're noting in the noting there.
You are challenging the Central Administrative Tribunal order.
Yes, ma'am. I will also file a reply to his counter. He has filed the reply. I will.
Yes, so is for the petitioner.
I am for the petition.
What is your submission?
I will file a reply to his counter. He has filed counter affidavit. I will file a reply to that.
Mr. This 2005 matter.
Yes, ma'am. I am for the opposite party.
How many
Matter-
decades will we
I
take?
thought that will fit, will complete that.
When was the counter affidavit filed?
Counter file, 31st July 2023, my lord.
23.
My lord.
Not even a second. They shall not give. any
Last
time.
2-3 occasions, they take time regarding instruction, how many payment. In the meantime, the opposite party attend the age of superintendence. Therefore, the court previous court directed to take instruction regarding payment of compensation and the matter may be closed.
So,
Compensation amount,
why? What is your instruction?
this is for the appellant.
You are for?
I am for the opposite party. They for the appellant.
Yes.
So you were required to seek instructions.
No, my lord.
Well, I
They have to the instruction regarding, though in the meantime, the opposite party has attained the age of superannuation. They have not been appointed for their lacuna. Therefore, they take instruction regarding any payment should be made, the matter may be closed. Earlier, this honorable court directed to take instruction regarding this matter. After 17 years, notice was issued. They take step and sleep over the matter. In the 2022 we appear.
Mr. Kaiguru, you have stated that you have got some written instruction.
Yes, ma'am. I will file reply, madam, to it.
Now, what is that written instruction you have got?
Should it be pleased, I will file that in paperwork.
In September 2023, you have sought for
Yes.
time, saying that you have already received written instruction and want to file by way of an affidavit.
After that,
Now
you
you
have
are
filed
not-
the counter affidavit, my lord.
6
So
months you don't have
I have to reply his affidavit. my lord.
10 lakhs.
Sorry, madam.
10 lakhs cost.
No, we have offered him 2 times employment, but he refused to receive that, my lord. It is a matter of compensation, compassionate appointment, my lord. We have given him 2 times opportunity, but he did not accept that, my lord. So I will show each and every document is there.
When will you show?
My lord.
When will you show?
Should that be feed so that I can.
10 lakhs.
He has filed a reply, my lord. So I can answer that. It will be convenient, my lord. Next week, also I will
around
let it come next week.
since that original file,
Yes.
2005.
Yes, 30 years. Where is the order of the tribunal?
It's 42, my lord. Annexure 3. And
What is the
subsequent.
direction?
No, my lord, kindly, page 55. Order dated 4/3/2024. The order of the tribunal. Page 55. Last operating part in page 56. Page 56, 4 lines bottom.
Yes.
Directed to appointment within a period of stipulation. That has not been complied.
This shall be, was there any stay?
Yes, ma'am.
Stay granted?
Yes.
Yes.
When?
In the
5 stays were granted.
2005 stay.
And after 17 year notice issued to the respondent. Notice, opposite party appeared in 2022. Stay order was granted, but the notice has not been received by the opposite party.
There was stay. They did not implement.
They did not take step in for appearance of the opposite party.
Appearance was material. Then what can be done now?
Any compensation?
Yes, what instruction do you have?
Well, I'll file an affidavit. Well, there is no compensation matter to that effect, as we have given him chance to occasions matter. And
When did
moreover,
you give him chance?
well, it is on record, my lord. I will show, my lord. And another thing is that, my lord, it is the compensation appointment as DOPT guideline is there, my lord. Each year they have to
5%.
frame the eligible persons who will be appointed under compensation appointment. Not that the persons who left, they will be carried forward to the next year, my lord. That is not done as per DOPT guideline. That is the whole difficulty. And 5% of the vacancy reserved for the compensation appointment. And taking into the income and liability, that has to be treated on priority basis. And moreover, the petitioners have given him 2 times chance. One, they have given one gardener, one cooking, but he did not prefer to do that. He directly refused that I don't know cooking, so I don't join on that post. Gardener also he refused. Lastly, he agreed that any post after 4 to 5 years. And another post was there, aircraft assistant, my lord. He has attended the interview, but my lord, due to stay of this honorable court, that appointment was totally stalled, my lord, for which we could not process. And lastly, that result was kept on seal cover, and lastly he did not qualify in that. So we could not give him any appointment.
What can be done, Mr. Counsel?
At the time,
Compensation appointment cannot be given to you.
your lordship, I know that.
Compensation, we are not finding any reason.
For fault of their, they have selected, they have stated in their counter that 2 posts are there. I am in serial number 2.
What can be done now? Nothing.
After
So fake it properly.
After 15 years, they have noticed.
15 years, we are yet to decide the merits of your case. Whether you are entitled or not entitled. So this writ petition is pending for last almost 20 years.
Yes, yes.
And stay was granted in 2005 itself, then nothing can be done.
But notice has not been sought.
Much prior to that.
Tribunal rightly allow the opposite party to join.
We don't know. We are yet to decide.
Yes.
But even if we decide, what will happen?
Without the fault of the opposite party, they linger in for years together.
We don't know. They are blaming you. That you did not accept.
I actually, in their document, that is that they, though the compensation appointment, but they have advised to take the face the interview. And face interview, they have been, though unsuccessful, they have been rejected.
We could not
But
advise him to face interview.
But the court directed to give any post group D and they may be appointed. But that has not been complied.
No, but you were offered the post of Mali. You were offered the post of Poo. That said you cannot.
Court had directed, but they had not been complied. Only they have taken interview. Interview, I am unsuccessful and rejected.
But he is saying that you did not accept to
that,
post of Poo.
That has not been correct. Lateral London Court below, in this case also directed to.
We are very sorry, we cannot do anything.
Lordship, any compensation
Compensation, how, on what basis?
Though after 15 years, they have.
So for that, we will have to dismiss his writ application. And dismiss writ application and affirm the finding of the tribunal.
As you lordship.
But without any. No purpose. Impugned in the present writ application filed by the Union of India is an order dated 4/3/2004 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 607 of 2001. Stop. The respondent herein is son of late Vincent Mohapatra, who was working as Mali under Aviation Research Center at Charbetia, who died on 16/9/1990. In harness. Oh, stop. He claims appointment on compassionate ground consequent upon the death of his father. Oh, stop. As his request to engage him on compassionate basis was not being considered, he filed an application before the tribunal giving rise to OA number 607 of 2001. Stop. The tribunal allowed the application of the respondent and directed the petitioners herein to provide a compassionate employment even against a Group D post within 90 days, by an order dated 4/3/2004. The aggrieved by the said order of the tribunal, as has been noted above, this writ petition has been filed by the Union of India. Stop. It transpires from the order sheet that this court, where is the stay order? Where is the stay order?
Yes, 24/2/2005.
This court, it transpires from the order sheet that the tribunal's order dated 4/3/2024 was directed to be stayed by an order of this court dated 24/2/2005. Stop. Since then, the said interim order has remained operative and this writ application pending. So stop. In the meanwhile, the respondent attained the age of admission. So stop. When did you attain that age? Superannuation
in 23
for a post under the Union of India in the year 2023 itself. Stop. Next, in such view of the matter, the direction of the tribunal, in such view of the matter, the petitioner's claim of the respondent for appointment on compassionate ground has, in such view of the matter, appointment of the petitioner on compassionate ground has lost its significance. Stop. We are of the view that no purpose will be served he attained the age of superannuation?
As per my instruction in 2023, the age 60.
Huh? How do you say? How do you say that he became 60?
You have got written instruction?
No, no.
And then? Have you seen the verification you filed before the tribunal? And cost title? What is the age that you have described?
Thirty years.
30 years in 2001?
Yes.
On what basis you are saying that you became 60?
Only oral, no, there is no document, my lord. I will take instruction.
Then counsel for the respondent does not have any specific instructions as to whether the whether the respondent is presently otherwise engaged or has attained the age of superannuation for any post under the central government. So place this case on 1 week.
So let's. Item 32.
May. I have taken time to file an affidavit mailers in revised manner, a newly affidavit manner. I
What
have
happened? Affidavit.
manner.
File.
Today I am filing the affidavit manner.
Today you are filing affidavit, and when will you argue?
Yes, I will. Yes, of the petitioner herein is challenge the order of the London State Administrative Tribunal, my lord, wherein the London Tribunal has directed to regularize my service on contractual basis, my lord. My case is that my juniors to me, there are 3 number of persons.
Yes, what is wrong in the order?
Wrong. My lord, kindly see the operative portion, page 32, the order of the London Tribunal,
Page 32.
my lord. Married. Considering the facts of the case, the present status as submitted by the London Council for the applicant and the government advocate and the pendants, I direct that respondent number 1 shall consider the case of the applicant for appointment of the applicant on contractual basis against a post of driver as soon as the collector's proposal in this regard cited above is approved by the finance department. My case is that, my lord, juniors to me, those who have appointed later on, their services have been regularized. I have annexed all the documents, my lord. And in their counter, they have not denied.
When were you appointed?
I appointed on, my lord, 10/12/1998. My appointment order had annexure 3, page 18.
Was there any procedure followed for your appointment?
As per the government resolution, there were so many number of vacancy posts of driver was lying vacant. On recommendation of collector, I appointed. Thereafter, some persons, those who have got appointment more than 3 to 4 years later on me, my lord, their services have been irregularized. I have enclosed all the regularization order, the similar situated persons. But my case, the London Tribunal has directed to give appointment order on contractual basis, not on regular basis. That part I have challenged.
Where is the right of regularization?
Since my case is since my juniors, those who have got appointment later on, their services have been regularized.
my case may be considered for regularization.
But their entry and your entry may be different.
They have not denied in their counter, my lord. They have filed a counter. They have not stated anything about that, my lord.
No, but tell us about your rights. See, the court follows legality, not illegality. So if they were appointed on by following some illegal means, then that would not mean that we will also follow that illegality. All right. So unless you make out a case that you had a right.
I have appointed against a sanction post, my lord. I have stated, my lord, and after due concurrence of the higher authorities. But they have not appointed against the sanction board, but their cases have been regularized.
Very difficult. At least you were protected by the tribunal. Otherwise, you could have been thrown out.
But my case is that since my...
But it is not against the sanction post. If you,
Well, I have mentioned, my lord, but...
If you come to page 17 and except 2, second para, your entry into service. On your representation, he has given some appointment.
I have stated in my read petition and I have taken...
This is not the manner in which the appointments are made.
But my yes, second ground is that they have, my lord, can see for a moment, my lord, annexure 14 and 11, page 29. Those, admittedly, my case, there is a violation of Article 14, my lord. Admittedly, those persons who have not got appointment, later...
Your appointment was not irregular. Only things which are irregular can be regularized.
They have not stated so, my lord. I have taken that ground.
All right, now I understood.
They have not stated...
All right. The petitioner in the present application has essayed an order dated 6/11/2020 passed in OA number 1620 of 2002 by the Odisha Administrative Tribunal, Bhubaneswar, whereby the learned tribunal disposed of the petitioner's application with direction to respondent number 1 to consider the petitioner's case for appointment on the post of against a post of driver on contractual basis as soon as the collector's proposal in this regard was made. This regard was approved by the finance department. So, assailing the impugned order, learned counsel appearing for the petitioner has submitted that the tribunal ought to have directed for regularizing the petitioner's appointment against the post of driver instead of directing his appointment on contractual basis. First off, he submits that persons appointed on ad hoc basis subsequent to the petitioner's appointment, services of the persons appointed after the petitioner
by the collector have been regularized and taking into account and giving due regard to the parity, comma, the tribunal ought to have directed for regularizing the petitioner's engagement. So stop. Next, we have carefully gone through the impugned order as well as other materials available on record. First off, we notice that the petitioner's initial engagement as driver on, which is driver on
10/12/1998. 10/12/1998.
daily wage basis.
Daily. On 44.
Huh?
44 days on ad hoc basis.
On ad hoc basis was made in the year 1998 by the collector based on a representation made by him to the collector. First off, no procedure at all was followed in consonance with Article 16 of the Constitution of India. First off, the petitioner, comma, in our considered view, comma, cannot claim regularization of service by way of right. First off, the tribunal, comma, by the impugned order, comma, directed the respondents, the opposite parties to engage the petitioner on contractual basis. We do not find any such illegality in the impugned order as would require this court's interference in exercise of jurisdiction under Article 226 of the Constitution of India. We do not find any merit in this case. This writ application is accordingly dismissed.
May I submit only one thing, madam? Kindly see page 33 for a moment, madam. Only one document. Their services have been regularized by interference of this honorable court. I have quoted the honorable court's order, and your honorable this honorable is directed to consider the government to consider his case for regularization. Thereafter, by interfering your lordship's order, their services have been regularized. In the order, it has been mentioned, man.
Item 33.
My lord, I will get a communication from the seven, my lord, that the Supreme Court has passed this order. But I'm little difficulty, my lord. Can I pray, let it come month of April, my lord? I'm in difficulty, my lord.
Actually, my learned friend is contesting the election, so we don't want to stand in the way. But subject to your lordships.
Your lordship may fix the date.
Date and your lordships may say also that nobody will seek for adjournment.
No, in that case, we can fix a date for fixing a date of it.
No.
That we can do. Otherwise, it's quite uncertain. Fixing a date at 2 months or 3 months.
No, my lord. In April, first week, your lordships.
First week of April.
First week of April, any date subject to.
Second week of
Elections are over.
Guys, he is contesting bar association.
Oh, we don't know, and we should not know.
Bar Association election, not.
Oh, Bar Association.
Not the general election, not the general election.
All right.
Election is on 30th March.
30th of March, my lord.
30th of March, so after first.
Second week of April.
Any date subject. Second of April. Second.
Second of April.
Second of.
Second. 8th April.
8th. My lord, may I pray? I pray that your lordship insist at 2 p.m. so that the
2 p.m.
Yes, yes.
2 p.m. That.
DPO. That's the name of my learned friend may be recorded because she is holding the brief for OP number 2.
For the state,
State.
Please give him.
And the interim order to continue till.
Interim order shall continue. As
Obliged.
currently requested.
Item 34.
No, item 34, my lord, pursuant to the press notice, my lord,
This is of 21st of February.
Yes.
This order. And the Supreme Court has requested us to decide it within 4 weeks.
4 weeks.
So if we should not violate the order at least.
Your lordships can keep a date in the interim, then your lordships can, subject to the convenience. Because there has been earlier orders also.
Because the matter is also pending in the
Supreme Court, the related earlier judgment has been challenged.
Earlier
So that is pending.
the cancellation of the lease in favor of my friend petitioners was
So
challenged.
will you take a plea that the High Court has violated
No,
the
we
Supreme
will.
Court's order?
No, my lord, we will say, my lord, I can personally. No, my lord, I can personally assure your lordship that before the Honorable Apex Court, we will say that on consent of parties.
You may not have control over your client.
No, my lord, that much we have at least. At least at this stage, we cannot.
With a lighter note, yes.
Because there is already, there is an order of stay of this
Cancellation.
allowing the petitioners writ application here. But the order passed in the writ application has taken effect by disposal of a representation, which he challenges here. So Supreme Court has kept it there and told that first instance, let it be over, then we'll be having. And
No, but since I will be appearing personally, I'll apprise the Apex Court, at least that much assurance I can give you.
We understand.
Your lordship is this is not done.
Yes.
Item 34.
Item 34.
Item 34, my lord, pursuant to the press notice issued by the Supreme Court, my lord, I entered appearance for the opposite party number 1 on 5th December 23, my lord. My lord, I pray 4 weeks further time to file a counter affidavit.
4 weeks further time.
May I pray, since your lordship has fixed that matter, Mr. Sahu's matter, OE matter, similar issues are involved. May I pray 18th can be better. Because same questions of law, deemed tenancy.
No, this is not deemed tenancy.
That is not deemed tenants.
That is not
That is a
deemed
difference. 38.
So I pray.
This matter is altogether different.
No, but these matters are pending for 12 years.
Any day subject to my.
Well, in December 23, I appeared in pursuant to the press notice, my lord. So I pray some time to file the counter affidavit so that I can properly assist your lordship in final.
Requested on behalf of the respondent. List this matter on 4 weeks.
4 weeks, my lord.
So as to enable him to file counter affidavit. Stop as the matter has remained pending in this court for more than 11 years. The court expects that the settlement counsel for the parties shall assist this court for expeditious disposal of the matter. Yes.
Interim orders are there.
Interim orders shall continue in India.
All three matters are similar.
Yes.
Item 35.
May please your lordship. This is a PIL matter, my lord. This is a PIL matter. Matter relates to fire safety measures in the premises of SB Medical College and Hospital, Cuttack, my lord. This matter appears today's list as per order dated 6th February 2024. Order number 17. The relevant paragraphs of the said order is at para 6 and 7. I would like to place those paragraphs if your lordship permits, my lord. Para 6. However, at this point of time, Mr. D.K. Mahant, the Illinois additional government advocate, contended that he may be permitted to file a better affidavit. Let him to do so within a period of 2 days. Please, this matter, after realizing the gravity and seriousness of the case, only because it relates to the life and property, not only the patient or attendant, but all the officials of the hospital, my lord. So, this honorable court was pleased to direct the government council to file the affidavit within 2 days, my lord. But instead of that direction, they have not filed the affidavit as would be evident from the office note.
My lord, we have filed the affidavit, my lord. It is on.
We have not received the, just now they are giving, my lord. Just to delay the matter, it is pending, my lord, for last 8 years. Fire safety.
No, but this should remain pending for more years because it's a public interest litigation.
My lord.
At times we keep issuing directions in such matters.
My lord, my great respect, your lordship, I would like to say this is a life and property. Fire safety measures is a life and death. Other matters, my lord, whatever you have said, it's right. But life and property of the people are in danger.
No, we are saying something else. These matters are pending and we keep issuing directions after regular intervals. Probably that will be more effective.
That will, my lord, that
we'll
is
see what can be done.
But 8 years have been already been lapsed, my lord. We have filed this brief application.
All right, we will do whatever you want.
Affidavit has been filed online and the hard copy I am serving you the.
Whatever you want, we will do.
Just now they have handed over.
Let him respond to this affidavit.
Let us see. Let us see.
We will respond to that affidavit.
Let me understand first.
My lord. May I pray, my lord, some time may be given also that the affidavit which has been handed over to me, I can give reply, my lord.
This is regarding what?
My lord,
This is regarding-
my lord, this is regarding fire safety measures, my lord.
Where?
In the SB Medical College and Hospital, Kotak, my lord. It's a big hospital. For the last 8 years, matter is pending, my lord. They are not able to install the fire safety measures. Life and property of the patient
My lord.
is in danger, my lord. That is my submission. That may I pray, my lord, let them complete the system within a short time, so that the life and property will be safe. That is
We have
limited
stated
prayer
in
of
our
the.
affidavit that the present status, and we are making efforts to complete it within 9 months. And I just to appraise your lordship, this SCB Medical College at Cuttack, there is a transformation and new buildings are coming up. Vast area is being utilized for the construction of the new building, multi-storied building, and expansion of the SCB Medical College. After those are become functional, the old building will be more or less abandoned. And the new buildings are already with this fire safety. Now my learned senior friend is saying that so far as the old buildings are concerned of SCB, that should be given fire safety measures. It is really a matter
It is
of
not now. It is since 2015.
And in the meanwhile, I have given affidavit. What has happened? Because your lordship may kindly have the affidavit which I have filed. Paragraph. The list of buildings in which the fire safety are available, that I have given, and 3 new building installation fire safety system in progress, and which will be completed by 14th May 2024. And so far as other,
whether this PIL is focused on only one hospital?
Yes, my lord, only
SB Medical College.
There are 3 big hospitals in the state of Orissa, one at Cuttack, another at Berhampur, another at Burla. These are prime hospital. It is only for Cuttack.
My lord, with a great respect.
PIL.
My lord.
And everyone is interested in the welfare of
my lord. Oblige.
You, him,
not
everyone.
My lord.
Yes. So,
yes. So far as others are concerned, we have applied for administrative approval. And once the authority gave the approval, I have mentioned the letters also in which we have applied for, and it will be completed within 9 months. That is the affidavit which we have given. We are making all sincere efforts to speed up the work and do this, because these are all year-old buildings. Your lordship may kindly appreciate these are very, very old buildings. That is why the new buildings are coming up, and the new departments will be opened there. That everybody
how
knows.
much time will it take for
that your lordship
new building to come up?
Your lordship, that new building, more or less that I can take instruction in within which period it will be completed. But if your lordship will see.
So what is your stand?
Para 7, I'm just placing.
What is your stand that the fire safety measures are not required in the hospital?
No. Fire safety is required and partly completed. So far as other buildings are concerned, old buildings, we have applied for administrative approval.
So you will have to do that on war footing.
War footing basis. That your lordship is correct in saying that. And I have stated, however, in the event the same is provided with regard to above mentioned buildings, the work is installing fire safety would be completed within a period of 9 months with active cooperation from the SCB Medical College authorities. Because your lordship may kindly imagine, all the patients have to be shifted from thereafter only the work can be. So these are all bottleneckings, and we have to do it in a proper manner because patients are not hampered by the process.
No, but this matter is pending since 2015. You have not been able to do it for last more than 9 years.
Yes, ma'am. That is the new buildings are coming up, and so far as the old buildings, we have already completed 11 buildings.
11 buildings of that college?
That area, pulmonary medicine department, drug warehouse, BSc nursing hostel.
You have completed?
All are completed.
This 87, what you have written, 87 numbers of buildings are there. That is inclusive of new building and...
No. This is all
old buildings.
Old buildings. Small buildings, hostels, colleges.
Director General Safety to be present.
Fire safety. What's it, we have given the.
Let him tell us the entire scheme, and we will monitor it
My lord,
weekly.
oblige, my lord.
So whatever progress is there, you just let us know
My lord.
on weekly basis.
This is your timeline, last page.
Yes, that is.
We accept that. We are not going to ask you to do something which is impossible.
Yes.
But we will supervise. You
Yes,
can
my lord.
take it like that.
Yes.
Oblige.
So we shall monitor.
Yes.
And in the order, the order which was passed on 11/1/2024. Superintending engineer has also enclosed a document to the affidavit wherein 9 months timeline has been given to complete the work.
Yes, that is also there in this affidavit, 9 months.
So that affidavit you can file 1 year after from today. Okay, it will take 9 months.
No, that 9
So
months.
you will not reduce that period.
No, 9 months from the date of that affidavit, that is to be.
9 months from the date of 11/1/2024.
Yes, because in this chart was given in the affidavit dated 11.
Let us see.
First affidavit.
But your para 7, as if it is from today. The same thing you have repeated. C/4. You have
Yes,
enclosed
same
C/4.
chart is.
But as if 9 months you are asking from today.
No, we will have him and
Would be completed,
would be completed within 9 months.
Within
with
9 months.
active cooperation from the SCB Medical College and authorities.
These are
So today you are filing this affidavit. Again you are 9 months.
within 9 months.
Already 3 months we have
already
crossed.
Within my this
In
is
January.
relating. This is with reference to the earlier affidavit.
How
That
can you
is-
say that? This affidavit doesn't say that.
May I pray, my lord, if your lordship permits, that this stand which is taken by the state has not been accepted, as would be evident from para 5 of the last order, wherein this honorable court has said that in one hand, the opposite parties are taking a stand that the work will be completed within so and so date. On other hand, they are stating that the work will be completed with the cooperation of SB Medical College, Cuttack, and Cuttack Municipal Authority and Fire Department, Government of Odisha, and also after vacation of patients and biomedical equipments from the above affidavit, the conduct of the superintendent engineer is tall and is blowing hot and cold at the same time.
All right, we have seen
Thus,
that.
My lord,
You're
my
not
lord,
required to read.
oblige, my lord.
Next one. This public interest litigation is of immense importance and relates to installation of firefighting system in, what is the full form? Subhash Chandra Bose.
No, my lord.
Sri Ram Chandra Bhanja Medical College.
SB Medical College and
Sri
Hospital.
Ram
Chandra Bhanja Medical
Bhanja
College
Medical College and
and
Hospital,
Hospital. SCB MCH.
bracketed SCB MPH, comma Cuttack. The hospital is indisputably one of the premier medical institutions of the state, having 87 buildings. There are 87 buildings.
Yes, my lord, that's right. 87 number, sir.
87 buildings. So stop. This writ petition has remained pending for more than 8 years, and we are of the prima facie view, based on the materials available on record and the order sheet, that that despite this court's intervention exercising writ jurisdiction, the progress in the direction of installation of firefighting system is not satisfactory, if not dismal. Stop. Next. An affidavit has been filed today, sworn by
Superintendent engineer.
the superintending engineer, Cuttack, bracketed R&B division number 1, Cuttack, from which it transpires that out of 87 buildings, firefighting systems have been made available only in 8, and work of installation of such system is in progress in 3 other buildings, which is likely to be completed by 14th of May 2024. Full stop. When it transpires that when the matter was taken up by this court nearly 2 months ago, on 11/1/2024, a stand was taken on behalf of the state that it would take 9 months to install firefighting system in all the buildings. So stop. Where is that? 9 months will take. 7. In the counter affidavit, in the affidavit filed today, it has again been mentioned that installation of firefighting system, the process of installation of firefighting system would be completed within a period of 9 months with the active cooperation from the SCB MCH authorities. So stop. Next. Absence of firefighting system in a huge establishment like SCB MCH Cuttack is a matter of serious concern. So stop. All the officers of the state are under obligation to take all effective steps and make endeavor, best earnest endeavor to ensure that the process of installation of firefighting system is expedited. So stop. So as to generate a sense of responsibility amongst the officials, concerned officials, and considering the officials, we officials, particularly since the matter has remained pending before this court for more than 8 years without any satisfactory progress, we consider it desirable to monitor the progress of installation of firefighting system in the hospital. So stop. Next. Full stop. Next. In the affidavit filed today, communication dated 3/2/2024 from the office of the Superintending Engineer Cuttack, R&B Division number 1 Cuttack, addressed to the Principal Tutor, School of Nursing, SCBMCH Cuttack, has been brought on record. A relevant portion of which reads as under. page 50. Got it. Page 50 का last paragraph. Stop. Place this matter on Tuesday next.
Next Tuesday.
To be taken up at 2 p.m. when the Director General Fire Safety Odisha and the Superintendent SCB जो hospital है
HCB Medical College and
with the deponent of the today's affidavit shall be required to be personally present in this court so as to inform us how the work of installation of fire safety system in the hospital can be expedited. Alert. Oh, so good. 13th. 13th.
Can it be 14th?
No.
13th.
13th and every Monday.
Every Monday.
13th I'll take up. We will take up on 13th.
Then
and thereafter every Monday.
Yes, ma'am.
Item 36.
Lordship, I am appearing for the petitioner. Yes, simply the Lordship. Initially, the case was filed against the inaction of the revenue authorities. Now it has come up by order of Honorable Single Judge before Lordship. The Lordship state I come to page 5 of the writ application. Had it been carried out, so there was no occasion to travel second time before this Honorable Court.
No, present to?
Page 5, Lordship. Had it been carried out, Lordship, because there is a direction by this Honorable Court at running page 5.
We have passed an order.
Lordship.
Have you seen that? What was that? What was that? Some funda. This relates to removal of encroachment.
Encroachment, so gochor land, which is prohibited under a revenue law, Lordship. No, if Lordship kindly see the section. Sorry,
my lord and Justice Sahu.
201.
Justice Sahu has passed an elaborate judgment.
Then I have not gone through, Lordship. I'll go.
Please go through that.
I'll go through, Lordship.
So, if some encroachment is to be removed from public land,
Lordship,
then that can, for that you can.
But it will suffice. Only that is entire cases here, Lordship.
8 minutes. That.
Just give the number. Huh? Yes.
That's section 130. 130.
What? It's WPC 3385 of 2024, Milords.
Please note down.
Lordship, 3385 I go through, Lordship.
So we have given direction. Whosoever wants any encroachment to be removed, they can invoke. They can.
Both 133, so also OPL Act also dealt with.
We followed that judgment in subsequent cases when I was.
Lordship.
21st of February 2024, date of delivery.
Will come tomorrow.
I'll go through, but Lordship, page 5, the similar order has been passed by Lordship earlier. Because they are in action, again I travel to Lordship.
I am appearing on behalf of opposition number 7 and 8, Madam. I have also filed a counter, Madam. May kindly have a glance to it.
So fight there. Before appropriate forum, not here.
Yes.
We'll come to our. See that order.
Lordship.
Madam, may I pray, Madam, may dispose of the application with that observation.
That can be no, but just see that order.
I'll.
If you say that your case is something
the entire villagers by virtue of Palli Sobha they have, my lord, made a my lord, giving their consent for the purpose of construction of a Kalyan Mandap. And it is also it has also been further, my lord, placed before the Panchayat Samiti. The Panchayat, my lord, it was also supported by the Panchayat Gram Panchayat. It has also been resolved that there will be a construction. And the 2017 construction was made, my lord, for the public purpose.
All right.
And now this particular person who is no way collected, my lord, will only become.
All right.
Lordship, interim or there, Lordship.
Tomorrow.
Lordship, interim or there.
Item 37.
37. Affidavit has been filed, I think, yes. Affidavit has been filed by the state and a copy has been served. Let's keep it to some other day so that I can go through the.
Yes.
I have served.
It is stated by learned senior counsel representing the petitioner that a copy of counter affidavit,
Not counter affidavit, additional
Counter
affidavit.
of-
As per my lord direction,
that a copy of an additional affidavit has been served today.
on Friday. On Friday, it has been served.
On behalf of the state.
Yes, ma'am.
Has been served on Friday.
My lord, last Friday.
Stop. An adjournment is being sought to consider this additional affidavit.
I put my interval, then let the state government to directly sort the
I will
copy of the
serve. No direction is required. I will serve.
Yes.
That is, he is your friend, you can obtain. The court will not pass any order unless your intervention application is allowed.
That's why, at least 1 week time and 2 weeks time.
This matter on 2 weeks.
Only madam, one miscase is there pending for intervention only. One miscase is there.
We will see when the matter is taken.
Implement.
Yes.
38.
Yes. Wait, please, your lordship. Whereas the learned single judge has directed
Time is over.
have it any day.
Tomorrow.
Gratefully. Interim order to continue.
Tomorrow.
Is there?
Great.
Well, I am responding.
Tomorrow.
Hopefully.
All the cases.
39,
39, my lord, things may be taken up 1 week after because my lord senior is not well. So my lord,
Who is appearing? Who is the
my lord,
that can be adjourned?
item 52. My lord, the interim order is there. So that.
As requested on behalf of the respondent.
Yes, ma'am.
Opposite party.
Yes.
Opposite party.
Respondent, my lord. Respondent opposite.
Respondent number?
Sole respondent, my lord.
Respondent. With the consent of learned counsel for the appellant. Senior counsel for the appellant. List this matter on when?
Yes, ma'am.
When do you want?
My lord, 1 week after, my lord, any day.
1 week. 1 week, Vivera.
Item
interim order shall continue in the meeting.
Oblast. Item 52 with your lordship's indulgence, my lords.
52, what do you want?
Admission. Can it be listed in the top 10 matters? I've been mentioning this matter last week, if your lordship remember.
So you could have told us today.
No, I think lordship was busy. My lordship was,
what?
I did not want to break the.
So tell us tomorrow.
But morning, I'll
tell us tomorrow in the morning. We'll...
Item 54, can we have it at 2 p.m. on any day, my lords? I hope
that we will decide once the matter is taken up. We don't know how important is that.
I like 53, my lord.
So tomorrow you just remind us that your matter may not be taken up, and then we'll try to take up your matter.
In that item 54,
Please ensure that other side is also available.
in the item 54, my lord,
state.
your lordship, the other side.
All this. Please inform him.
Your lordship, item 53, your lordship. May kindly be listed for tomorrow, your lordship.
It will be there tomorrow.
That item 42 may be taken up on 7th.
7th?
We are for the respondent, he is for the appellant. On 7th.
Seek her consent.
Yes, I have taken.
As requested on behalf of the respondent.
7th March. So that's an interim order.
Yes, I know.
As requested on behalf of the respondent. List this matter on. When do you want?
7th March.
7th. Interim order shall continue in the. Yes, any matter?